Original side mentioning.
May I have your lordship's kind leave to mention a 36-2 application, your lordship. Your lordship had passed an order on 27th September 2023 directing to deposit a sum of rupees 8 lakhs approximately by way of bank guarantee with the registrar, your lordship, within 2 weeks. However, I could not obtain the bank guarantee within 2 weeks. The bank guarantee is ready with lying with me, your
We
lordship.
mentioned tomorrow. Notice to the other side.
Can it be on Monday, your lordship?
No, no. Why Monday?
Very well,
Tomorrow.
very
It's
well,
ready.
very
You according to you, it's ready.
Very
Yes. Yes.
My lord, may I be permitted to mention, my lord, a section 34 application, my lord. I'm the award debtor in the proceedings, my lord. They've been enjoying an order of stay, my lord, since 16 June 2022, my lord. I filed my affidavit in opposition, my lord. I've served upon them a copy, my lord. It's only to be heard, my lord, as an adjourned motion, my lord. My lord,
Last heard on?
Last heard 27th April 2023. Matter hasn't been heard, my lord. There was liberty granted to mention, my lord. I have the last order, my lord.
Not required.
My lord, I'm an award debtor, award holder, my lord. I've been enjoying.
But 29th April, what were you doing all this while?
27th April, my lord, we filed our affidavits, my lord. It's for
Complete an anniversary, then you mention.
My lord, I'm for the respondent. The petitioner hasn't been taking steps, my lord. I'm for the respondent in the section 34. That's the only difficulty, my lord. Any day.
Yes, 30th January, notice to the other side.
Deeply obliged, my lord.
May I be permitted to mention one section 9 matter for withdrawal? The matter has been settled out of court.
Of which year?
2023.
Kal diye do.
Lordship, may I have your leave to mention an execution application? Lordship, the matter has been settled between the parties for withdrawal, Lordship.
যদি কালকে না পারো সোমবার দিয়ে দাও. Any other mentioning? Or appellate side?
Appellate side mentioning. May I have your lordship's kind leave, my lord, to mention.
Microphone, please.
May I have your lordship's kind leave, my lord, to mention a part heard matter, my lord. My lord, this is that matter where, my lord, allegations of sexual harassment were leveled
Can't
against.
understand. Speak clearly.
My lord, this is that matter where, my lord, allegations of sexual harassment was, my lord, leveled against a registrar of a university. My lord, it last appeared before your
NUJS?
NUJS.
কবে থাকে এগুলো? Yes. Who was arguing? Mr. Pratik Dhar?
My lord.
And Ms. Joydeep Kaur?
My lord.
15th or 22nd? It only has to be on Mondays.
Any day, your lordship.
22nd the other.
So by
Notice to the other side, please.
Lordship, may I be permitted to
Microphone, please.
may I be permitted to contempt?
Appellate side can be this microphone also.
May I be permitted to mention one contempt application?
Can't hear you. Very well. You adjust the microphone on Monday and come and mention. Call on the list, please.
Several times.
Call on the list. Call on the list.
I have mentioned the contempt.
Call on the list, please.
Item number 3, Government of West Bengal versus Essex Development.
Your lordship had, my lord, occasion to perhaps, my lord, deal with this matter. This is
Item number 3.
3, my lord. 3 and
Item
30.
numbers 3 and 30, lordship. I appear for the award holder.
These concerns, my lord, the dispute between Holdia Petrochemical and Punendu Chatterjee, my lord. That is. So I am wondering, my lord, if your lordship is inclined to take it up, we have no objection.
No, I'm also wondering as to why you would mention the kind of a roll call. I will go entirely by what you want. Both of you.
No, my lord, it is not what we want.
My
My
lord,
lord,
we
if your
have no
lordship, my lord, if your lordship has, my lord, desires to take it up, we also have no objection.
Sure. Which page? Page 28.
My lord, the agreement, my lord.
My lord, we've not been served with the section 34 or the section 36.
No, so then what is this? What is AP 28?
My lord, we don't know, lordship, because we...
My lord, item number 3 is, my lord, section 36.
Stay of operation 36.2. Yes, Mr. Dotto. This is 28 is 36.2.
Yes, 36.2.
And where does the award page 28? Give me the last page of the award, please. Is that in volume 1 or
It's in the
volume
volume 2.
volume 2?
But in fact, where the award is for refund of tax, which Milord is not permitted, Milord, in the law.
That is not the award. That is not.
There are multiple awards.
On the award. There is Milord, there was Milord, this is Milord that Haldia Petrochemicals. Now, Milord, there was a share purchase agreement where Milord the government and Milord is out. Mr. Doctor, this is that is what. So this is that Haldia Petrochemicals. That in the sense, Milord, where Milord the Haldia Petrochemicals. And I
From my independence or integrity.
But that Milord I leave to the court. I cannot say anything, but only thing what I was told that Milord, at some point of time, Milord, in connection with this matter, Milord, under the 2nd January agreement, my Lord was appearing.
2002.
Yes. Yes. But we are told that, of course, Milord, I was not in the litigation at that point of time. We are told that at one point of time, Milord, including Milord, the withdrawal of the litigation.
Very well. So there is a suggestion of that. Yes. Learned counsel, the learned advocate general appearing for the state of West Bengal, government of West
IAPA
Bengal.
for
It
the
was
state of-
government of West Bengal, wasn't it?
Government of West Bengal is,
Not
I am
state.
representing the government.
The IAPA for the West Bengal Industrial Development.
Yes. The advocate general, the learned advocate general, appearing for the government of West Bengal, comma, who was one of the parties to the arbitration agreement of 2nd January 2002. Was it 2nd or was it 12th? 12th January 2002. Submits that I was one of the counsel who was involved in the litigation pertaining to the agreement, capital A. Stop. It is also submitted that the impugned award, comma, which forms a subject matter of the present application for stay, comma, arises out of the said agreement. Stop. Capital A.
Milord, it is a fallout of that 2nd January agreement.
Yes,
which is an-
arises out of কেটে দাও, is impugned award যেটা বললাম is a fallout, একটা কথা, fallout of the agreement dated of the arbitration agreement. Stop. Next, APCOM 28 of 2023 is accordingly released from my list.
My lord, may I make one submission, my lord? That submission that it rises out to the 2002 agreement, that is actually not correct because the arbitration agreement is a completely separate agreement arising from the share purchase agreement of 11 September 2014. My lord, my lord kindly records because this may prejudice us in future because this submission is not correct, perhaps, Lord.
Mr. Sharkar, the fact remains that if there is a doubt, then the court must release.
Lordship. However, Lordship kindly records
Because
that
it's
this-
not about what the court feels, how independent the court is.
Lordship,
The court, the
Lordship.
perception is what
I
from the other
appreciate,
side.
Lordship. Only thing is, Lordship kindly records that we dispute that submission as to the connection
Very
between the two agreements.
Yes, learned counsel, next learned counsel appearing for the
Award holder.
respondent award holder. There were 4 parties, so you're representing all of them.
Lordship, the disputing parties only concerned one Essex Developments, which is a
Yes, very well.
group company.
Appearing for the award holder submits that the impugned award arises out of an agreement dated 11 September
2014, Lordship.
2014.
That's all, Lordship. That's all.
Stop. তারপরে লেখো, the matter is due to the submissions, in view of the submissions made, comma, the matter is released from my list.
My lord, item 30 as well, Lordship.
30.
30 is the section 34.
APCOM 27 of 2023, comma, which is an application for setting aside of the impugned award, is also released from my list.
Grateful, ma'am.
I'm grateful.
Namaste, my lord.
Act-
Namaste. My lord, my prayer is to list
Item
down
number
my
4, Ganariwala 3PL Private Limited.
My lord, this is my application under section 11 of the Arbitration and Conciliation Act. Lordship will recall, my lord, the first day, my lord, when I had moved this app,
When is your where is your other side, Mr. Jain?
lord, he had appeared on 2 occasions, my lord. Today I don't see him.
He had appeared,
Yes, my lord.
and
Oh,
last
my
time
lord,
was
my lord, the learned side's the clerk is, my lord, is informing me, my lord, that he's stuck somewhere, my lord.
just 1 minute. পিটিশনের বানানটা কি? লাস্ট অর্ডারটা দেখো তো। কি মনে হয় তোমার? Yes, you can start making actor line add করো. First line. The order passed by the court on 19 December 2023 contains a spelling mistake. Stop. The word petitioner should be spelled as আবার ভুল বানানটা দিয়ে দিও। Let the correction be made in the order.
My lord, the disputes arise out of an agreement dated 7th of January 2022, my lord. There, my lord, I am described as a landowner, my lord, and the respondent, my lord, at page 14, my lord. At page 14, the agreement starts, my lord.
7 January 2022, you said?
Yes, my lord.
Yes. What is the agreement for, Mr.
But,
Jain?
my lord, I owned a land measuring around 1,50,000 square feet, my lord, somewhere in Burdwan, next to, my lord, the Andal airport, my lord, which has come. My lord, I was to, my lord, construct a warehouse and give it to the respondent, my lord.
Warehouse for what?
Warehouse, my lord, they can use it for warehousing purpose, my lord, the commercial utilization of my space, my lord.
Yes.
And my lord, the terms were agreed into, my lord, and my lord, agreement entered into between the parties, which contained, my lord, an arbitration clause. Disputes arose, my lord. Immediately after execution, my lord, they started, my lord, pressurizing me, asking me to modify the terms of the contract, my lord. I did not give in to that, my lord. As a result of which, my lord, they terminated the contract. On last occasion, my lord, what they said, the submission made by the learned counsel, my lord, was that my application is premature, my lord. Why, my lord? What they say, my lord, is in view of, if my lord kindly turns to page 18, my lord.
1-8.
1-8, my lord. They said, my lord, there is
Your application for appointment of arbitrator?
my lord, this is an application for appointment of an arbitrator. My lord, they said, my lord, it is premature because, my lord, there is an pre-mediation clause,
Yes.
pre-arbitration mediation clause, my lord. And my lord, without exhausting that, my lord, I cannot go for arbitration, my lord.
And joint committee and all that, who will form?
My lord, this was to be formed by both. My lord, in my respectful submission, my lord, this has been given a go by themselves, the respondent themselves, my lord. Why, my lord, if lordship kindly permits me to place this provision?
Yes.
Page 18, my lord. Any dispute, difference, or controversy of whatever nature, howsoever arising under, out, or of, or in relation to the agreement between the parties, and so notified.
Mr. Jain, I've read it.
So, my lord, I notified, my lord,
Yes.
the moment I notified, my lord, that it was incumbent upon the respondent, my lord, then, my lord, to have initiated mediation. They did not. They do not respond to my notice invoking arbitration. Then, my lord, if
No,
lordship,
but did you make any attempts at mediation?
my lord, I did not make attempt, my lord.
Yes.
But
Then what did you
if
do?
my lord also sees the rest of the clause, my lord, as regards mediation is concerned,
Yes.
my lord, mediation is only confined to, my lord, for implementation of the agreement. My lord, today, my lord, the agreement has been terminated. If lordship kindly sees the third paragraph at page 18, last paragraph. The joint committee comprising of 3 authorized representatives, including the concerned regional manager of so-and-so and equal number of authorized representatives of the petitioner, concerned shall be authorized after going into all pros and cons without jeopardizing the financial interest of CWC as contained in the agreement. And my lord will kindly see for what? To amend the terms and conditions for smooth and hassle-free operation. So long as overall structure of this agreement does not change. So, my lord, mediation is only confined, my lord, for the smooth implementation of the agreement. Now, today the agreement has been terminated, my lord. There is no question, my lord, in my respectful submission, my lord, for going for mediation, my lord. And in my respectful submission, my lord, they are the ones. The respondent is the one, my lord, who has given a go by to this particular clause, my lord.
How? How have they
My lord,
done
because my lord, they have terminated, my lord. I write to them, my lord, saying that there is a dispute, my lord.
that? When did they terminate?
My lord, the termination, my lord, is at page 52, my lord. 12th of July, 2023. Page 52, my lord. There was a typographical error, my lord, in the communication of page at page
Yes.
50. So the termination notice is dated 12th of July 2023. Lordship will see agreement is mentioned as in the reference column. Agreement is dated 7th of January 2023. Though, my lord, it is an agreement of 7th of January 2022. My lord, they correct it later, my lord, which lordship will find at page 55.
Yes.
My lord, language of both the notices are same, but for, my lord, the date of the agreement, my lord, the year of the agreement. They terminate, my lord. Now today, my lord, the only remedy for me, my lord, dispute has arisen. My lord, that has to be.
And when did you invoke?
My lord, my invocation notice, lordship will find at page 57, my lord. 27th of September 2023, my lord, which was duly served, my lord.
And did they reply to that?
No, my lord. My lord, that is what I was about to say, my lord. That if they wanted the mediation, my lord, they could have, my lord, responded to this, saying that okay, there's a mediation clause. Though, my lord, on the first occasion, lordship will recollect, they said that they had responded. They were supposed to bring the letter, but they, my lord, on subsequent, my lord, on 19th December, they said, my lord, there's no such communication.
And what is paragraph 3 at page 58, Mr. Jain? Why do you say that?
Because, my lord, we did held numerous meetings. We did held. My lord, those are all documented in the communications. My lord, I am not troubling your lordship. Lordships will find the communication starts from page 21 right up till page 50. If my lord sees my response at page 30 and page 46, my lord, I made it clear, my lord. At page 30 and at page 46, my lord. Those are my responses, my lord.
Very well. Mr. Jain, I'm keeping this matter tomorrow.
Hello.
I will dictate the order. I will give them one chance to appear. All right. And what is your claim? Same amount?
My lord, my claim is on account of damages, roughly
No,
around,
what,
around 2 crores, my lord.
2 crores. And that is on account of?
Damages, my lord.
Damages. Damages for?
Damages because, my lord, I have been made to, I have constructed the building, my lord. I have put my money, my lord. and without any return, my lord. I've invested huge sum of money.
Very well. And they are based in?
My lord, their registered offices in Delhi, but then they have their
No,
office
then
in.
Mr. Jain, I will keep it on Monday. All right, Monday you come back and you communicate this order on them.
Yes, ma'am.
Learned counsel appearing for the petitioner has placed the relevant documents to show that the petitioner has a claim for damages amounting to approximately rupees 2 crores on account of the respondent terminating the arbitration agreement with the petitioner on 12th July 2023. Stop. Next, the respondent, no one, the respondent is not represented today, despite the fact that counsel had appeared for the respondent on the in the last two previous occasions. Stop. Next. List this matter on 15th, on 8th January 2024 for giving the respondent one last opportunity to make its submissions. Stop. Next, the advocate on record of the petitioner will communicate this order on the respondent in the course of the day.
Item number 5, Mrs. Krishna High Tech Infrastructure Private Limited.
Receive this section 11 application.
Microphone, please. Where is your other side?
Appeared when we filed.
I can't hear you. Tell me when you serve them. Don't look. Obviously, they are not there. What will you do looking that side?
14/12/2023.
Sorry?
14/12/2023.
So at least communicate this order on them and come back. When do you want to do that? Where are they based? Sector 5. When do you want to come back?
Next week.
Give me a date, please. 8th, 9th?
No, 8, 9. I'm at Supreme Court.
So give me the date.
Friday?
You don't know that Friday is a holiday?
Friday.
Yes, the respondent was served sometime in December 2023 and is not represented today. Stop. Next. List this matter on 15 January 2024 as before. The petitioner's advocate on record will communicate this order on the respondent in the course of the day. Next.
Item number 6, Shubham Enterprise.
I beg to appear on behalf of the respondent.
Yes.
They are appearing on behalf of the petitioner.
Section 11.
Petitioner before your lordship was awarded.
Mr. Dotto, microphone, please. Mr. Bhattacharya, why are you objecting to this?
The fact remains, my lord, that the final bill was submitted. Pursuant to that, my lord, the payment was made, my lord, sometimes in the month of March, my lord. Now thereafter,
March of
my lord,
which year?
March of 2023. Now that was acknowledged. The contract stood concluded. Now suddenly in the month of June, a fresh claim was made by way of a representation in lieu of, my lord, escalation and in lieu of, my lord, GST charges. So, my lord, our understanding is, my lord, that the agreement, my lord, it has, my lord, the terms has, the agreement is, it is a concluded contract, my lord, and the payment has been made. But they are now trying to.
Mr. Bhattacharya, that is on the merits.
Yes, I cannot deny
That is
the
on the
fact that
merits.
there is a clause, my lord, insofar as arbitration is concerned. So, in fact, my lord, I was having a word with Mr. Dotto, my lord, my client, my lord, the IIT Kharagpur, my lord, technology, my lord, Indian Institute of Technology. Now they have technology. Now they have suggested the name of one learned advocate, my lord, which I have conveyed to Mr. Dotto as well. And he says also that he has no objection if a single arbitrator.
Mr. Bhattacharya, the court will decide.
Very well. I leave that entirely upon you, lord.
Yes, Mr. Dotto, just give me the facts because that the order must reflect the facts. Yes.
My lord, on the contract was awarded pursuant to the notice inviting tender 27th of January 2020, and my lord, letter of acceptance was issued on 13th of January 2021.
What was the contract for?
Contract was for the resurfacing and the repairing of the bituminous road inside the, my lord, Kharagpur campus. The, my lord, the worth of the subject project was around 11 crore and odd figures. And subsequently, my lord, the 3 extensions have been granted, and subject project was completed on 30th of November 2022.
Completed.
Completed.
Yes.
This is the actual date of completion after giving, my lord, the extension of time. 25th of, my lord, April 2023, completion certificate was issued by the authority, and, my lord, at page that 68 that has been mentioned. The letter of demand was issued on 10th of May 2023.
Letter of demand. So some amount paid or nothing paid at all?
Nothing paid at all.
Nothing paid. So that was 10th May 2023.
10th May 2023 at page 69, my lord. The amount was 5 crore 94 lakhs 4,926.
Yes.
My lord, the section 21 notice was issued on 19th of June 2023. Since, my lord, it appears from the, my lord, the clause 25 at page 52, my lord, I am drawing your lordship's attention.
That's the arbitration clause.
Arbitration clause.
Page 52.
Page 52. My lord, I am drawing your lordship's attention at page 50.
So there are 3 arbitrators.
3 arbitrators. My lord, in consonance with the clause, we have already appointed our arbitrator, but we are not willing to do it because, my lord, it will create more expenditure. And therefore, my lord, since Mr. Bhattacharya is giving consent, in that event, my lord, one single arbitrator would be, my lord, suffice. And other aspect is also there, my lord. The venue has been mentioned in Kharagpur, and my learned friend has already consented to.
Written instruction so far as the arbitrator is
Mr. Bhattacharya, you have to address the court, and I will come to you after this.
No, my lord,
Yes.
in that event, I don't have any say. Only, my lord, so far as the appointment is concerned.
What that event you don't have any say? What is the venue?
The venue is at Kharagpur, my lord.
Where is it?
25.2.
Yes, shall be held at Kharagpur. Yes.
So, my lord, I am leaving the matter to your lordship, my lord. And so far as the appointment is concerned, one, my lord, learned advocate has been appointed. But, my lord, if your lordship pleases to appoint someone.
Where is your 21 notice? That is at page?
That is at page, my lord, 159. Volume 2, my lord.
Para 7 is there.
Yes, I've seen that. Very well. Yes, Mr. Bhattacharya, what and have they replied to this notice, 21 notice? They haven't. Yes, Mr. Bhattacharya.
The final bill was submitted, my lord, and on the basis thereof, the payment was made, my lord.
Yes.
Now, but the final bill was submitted, the 8th and final bill on 14th of March 2023. Payment was acknowledged. Thereafter, my lord, suddenly in the month of May, this particular representation, which is being relied upon by my learned friend, my lord, now that was received by us, whereby, my lord, he is claiming for escalation and GST my lord, amount in lieu of GST charges, my lord. Well, this, as I indicated, my lord, that my lord, the contract stood concluded, my lord, nothing remained, my lord. There was, my lord, full and final settlement. Now, thereafter, my lord, an attempt is being made, my lord, to reopen this, my lord. As I indicated also, my lord, that...
No, because Mr. Dotto said that nothing has been paid.
No, my lord, it has been paid. I have
So
documents.
far as the letter of demand has been concerned, my lord, nothing has been paid.
After the final bill, my lord, nothing remains. Now, this is, my lord, nothing but, my lord, a claim, my lord.
Very well. So, Mr. Bhattacharya, you're agreeable to one arbitrator.
Yes, my lord. We are agreeable to one arbitrator, my lord.
And what is your claim now, Mr. Dotto?
Claim is, my lord, 5 crore 94 lakhs 4,926.
Which is completely disputed by us.
At page, my lord, 69.
Very well. The arbitration clause is contained in a contract dated 13 January 2021, which was awarded by the respondent to the petitioner for repair of bituminous road, you said?
My lord.
Bituminous
Resurfacing and the repairing of the bituminous road.
for resurfacing and repair of a bituminous road inside the campus of the IIT, Kharagpur. Stop. Next, the petitioner claims, the petitioner, through learned counsel, claims that the petitioner completed the work on 30th November 2022, and the respondent handed over a completion certificate on 25th April 2023. Stop. The respondent also gave 3 extensions before the petitioner completed the work. Stop. The petitioner, however, issued a notice, a letter of demand on 10th May 2023 for outstanding dues of approximately rupees 5.94 crores, and thereafter invoked the arbitration clause in the agreement on 19 June 2023. Stop. The respondent did not reply to this notice. Stop. Next, learned counsel appearing for the respondent submits that the letter of demand of 25th April 2020, of 10th May 2023 was after the respondent had made substantial payments to the petitioner in terms of the final bill raised by the latter.
A
Stop.
total of 7 crore 12 lakhs 96,743.
Stop. The respondent, according to counsel, the respondent paid approximately rupees 7.12 crores.
Including 12% GST.
And stop. According to counsel submits that the demand made by the petitioner is hence after conclusion of the contract between the parties. Stop. Counsel, however, does not dispute the existence of the arbitration, an arbitration agreement. Stop. Next, upon hearing counsel appearing for the parties, the court is of the view that there is indeed an arbitration agreement which exists between the parties, and also disputes in terms of the alleged outstanding claims of the petitioner for the work done. Stop. The respondent, of course, disputes this, the quantum as well as the claims. Stop. Next, parties, however, agree that instead of 3 arbitrators, as provided by the arbitration agreement, the parties will be would be better served by appointment of a single arbitrator. Stop. Next, AP Com 30 of 2023 is accordingly allowed and disposed of by appointing blank. To be communicated by 5th January. To be communicated by 6th January 2024.
Great.
7, Sonic Thermal Private Limited.
That 2 purchase orders dated 16 July 22 and 18th December 22. For
16 July?
Yes, 22 and 8th December 22 contained arbitration agreements. There are also sales contracts it is my case, my lord, that the purchase orders are the final repository of the terms. My learned friend's case is that the sales contracts, my lord, are the repositories of the terms.
No, so after the two purchase orders, what happened?
My lord, we were required, my lord, to purchase goods. We put in, my lord, the advance. There has been failure of consideration since the entire goods. my
No,
lord,
what
have
is the
not been
contract
given.
for?
Contract is for sale, my lord.
Sale of
Sale
what?
of manganese iron.
So you will sell,
I will buy.
you will buy.
And I paid, my lord, advances. There has been failure of consideration. Also, my lord, in view of refusal to supply, I had to buy from somewhere else. So the difference in price is my claimant damages. Total claims, my lord, should be in the region of 5 crores. Both, my lord, together. Now, my lord, under a misconception, my lord, we had issued a notice to an arbitrator nominating him. He, my lord, appreciated
Why
that.
misconception?
My lord, because he under misconception, he proceeded to believe, my lord, without their consent, that he was that, my lord, he had jurisdiction. They, my lord, filed a section 14. We consented. And, my lord, the mandate was terminated.
And so hearings held or not?
I'm sorry, my lord.
Hearings held.
Twice, but no
Twice.
progress. We agreed, my
Yes.
lord, that he didn't have jurisdiction. We are agreed to appointment of an arbitrator. The council are agreed, my lord. There's no way out of this. The only thing is, my lord, whether it should be purchase order or, my lord, the sale contract. That is the only divergence. But the notice referring disputes to arbitration is at page 129.
No, but there's no correspondence before that.
Yes, there is, my lord. There are from page 93, my lord, there are some documents.
So 93 documents saying what? What
This
did
is
you
on
ask?
the merits of the dispute.
So you're saying that they did not supply and you had to buy from somewhere
Yes.
else.
The usual, my lord, sale of goods
And
case.
section 21, after that, what happened?
After that, my lord, they did not my lord, they did not concur to the appointment. So, my lord, we have approached your lordship for appointment.
No, so they replied to that. Where is their reply?
My lord, there's no reply.
There's no reply.
No reply. My lord, 129 is the
So 11.5 as well.
Yes.
Yes, Mr. Ghosh.
Lord, I'm consenting to the appointment of the arbitrator only subject to the fact, my lord. Perhaps the facts indicated by Mr. Chaudhary is not correct. My lord, they have lifted the goods. There was a timeline within which they had to lift. They failed to do so. As a result of which, my lord, the contract stood determined. And my lord, they had also
So there's no formal termination of the
No.
contract.
They, my lord, because the timeline is there and it's a strict construction of the timeline. Well, they preferred a section 9 application. They moved it ex parte. They got an order of injunction. That, my lord, upon hearing the parties, my lord, it's been vacated. Before the section 9 court, they had consented to the fact that section 4, that the arbitrator cannot proceed further. They, in the section 14, they have not. These are differences in the facts. So I am consenting to the appointment. Lordship will kindly not
Show me the
record.
arbitration clause, please,
Yes,
Mr. Chaudhary.
Yes, my lord. My lord, page 14, my lord. Yes, my lord. This is the
So there's
purchase.
no dispute as to whether the purchase orders are linked or whatever. Usual dispute. And it was a consolidated letter, 21.
Yes, my lord.
Where is the arbitration clause? I can't find it.
My lord, this, my lord, at page 14, my lord, 3 paragraphs from the bottom.
I can find something saying Tration.
Yes, my lord.
Tration, that is the one.
Lord, if I may be permitted to say this, my lord, if
May
a chamber colleague would have been present, he would have said there's a pathological clause.
there is only a difference between, my lord, page 14 and 15. 14, my lord, says bitration and 15 says tration. So, my lord, otherwise, my lord,
No, there are all the other clauses also have shuns, so it's all right. And the last one is, of course, marks.
yes.
Yes, the dispute between the parties arises out of arbitration clauses contained in two purchase orders dated 16th. Mr. Chaudhary and Mr. Ghosh, please pay attention because the facts may be wrong from whatever I've heard. Ki bola? Two purchase orders, arbitration clauses contained in two purchase orders dated 16 July and 8 December 2022, which were issued by the petitioner on the respondent for supply of manganese ore. What did you say?
Manganese ore.
Manganese ore.
Yes.
ORE. Manganese ore. Stop. The petitioner, next, the petitioner, comma, through learned counsel, comma, claims that the respondent failed to supply the agreed quantity of the material, and the petitioner was hence constrained to purchase the material from other sources, incurring substantial additional expenses. Stop. The petitioner, according to counsel, comma, the petitioner hence has a claim in damages. Stop. Next, learned counsel appearing for the respondent submits that the takes an objection to the narration of facts as presented to the court, but does not dispute the existence of the arbitration clause. Stop. Next, the admitted fact is that the petitioner invoked the arbitration clauses in the purchase orders by way of a notice dated, what is the date?
19th August 23.
19th August 2023. And the respondent did not reply to the notice of invocation. Stop. Next, the parties, from the submissions made on behalf of the parties, comma, it is evident that there is a dispute which is relatable to the arbitration agreement which exists between which exists between the parties. Stop. Next, APCOM 31 of 2023 is accordingly allowed and disposed of by appointing blank paragraph the other way to be communicated by 6 January 2024. And your claim is 5 crores.
Yes. The next matter and this matter put together, the claim is 5 crores.
Very well. Pointed out.
Item number 8 is Ispat Damodar Private Limited.
Same parties?
Yes. Well, not same parties. The respondent is the same. The petitioners are different. One is Sonic Ispat, the other one is Ispat Damodar.
So why are you saying that it should be together 5
Because
crores?
in the first matter, my lord, the claim is 78 lakhs plus damages. In the second matter, it's 1 crore 27 lakhs plus damages. So
you want the same person to be
yes,
appointed?
if it makes commences to you.
So you heard the order. What should be the factual differences?
My lord, the dates are also same, excepting the fact, my lord, the quantum of the claim should be consolidated between the two.
No. What corrections should I, what additions, changes should I make in this order?
Nothing. There's no change. The dates are also the same.
Yes, dates of the purchase orders are also the same. And invocation notice?
Same.
19th August. একই order হবে combined order না দুটো আলাদা order হবে
While deciding on personnel, your lordship usually asks us to indicate the quantum with damages and
that is only for choice of
Yes,
arbitrator.
so that's why, my lord, I'm indicating with damages and failure of consideration. I think each would come to around 4-5 crores.
Each
4 crores at least. That would be my client's claim. And I'm sure they would have counter claims.
Very well. একই order হবে
Look, the allegations are not admitted in the made in the petition are not admitted by us.
Yes, একটা line add করে দাও, the counsel appearing for the respondent does not admit to the allegations made in the petition. Stop. I don't know what difference it will make to you.
That's why I asked
Because
him.
I'll just
It's
indicate
in section 11.
only to the extent, my lord, because they have stated something at paragraph 13, which is perhaps factually incorrect. That is why.
Anyway, the final decision will be of the arbitrators.
Nine, Vishwadip Chakraborty.
This is my section 11 application.
Just one minute. Yes.
This is my section 11 application. The agreement is an agreement for assignment or transfer of lease dated 6th of May 2023. Of lease of 6th of May 2023. The agreement starts at page 49. The arbitration clause is clause 20 at page 50.
No, who will transfer to who?
The respondents were supposed to transfer their leasehold interest in respect of a property in Salt Lake in favor of the petition.
Yes.
And my lord, in respect of this, the arbitration clause is at clause 20. In
Where
terms
is
of
that?
the agreement, what clause 20 is at page 50.
Don't rattle off like that. Where is the arbitration clause?
Page 59.
59. Yes. What else?
Yes. Now, if Lordship sees page 53, there were obligations upon the respondents immediately upon execution of the agreement, clause 1A and 1B. First, to get their names mutated in the records of the authorities, and secondly, to pay all the arrears of the municipal taxes. That is, my lord, at page 53.
Page 53.
Page 53, my lord. Clause 1A and 1B.
Yes. So they were supposed to do all these things.
Yes, they were supposed to, these were their obligations which they had. And now if your lordship takes page 55, clause 4, the total consideration for the assignment or transfer was 1 crore 72 lakhs.
Clause 4.
Clause 4, my lord, page 55.
So you would have to pay this amount to them?
Yes, I was to pay this amount to them, out of which, my lord, in terms of clause 4, Roman 1 and Roman 2, I've already made payment of a sum of rupees 15 lakhs to the respondents.
So outstanding remains.
Now, in respect of the outstanding, if your lordship kindly sees clause 4, Roman 3, the remaining part was to be paid, that is one part of the remaining, that is rupees 35 lakhs, upon the obligations mentioned in clause 1A and clause 1B being complied with by the respondents.
So according to you, they haven't done this? So you
They
haven't
did not
paid.
do it. Now, there has been correspondence in the form of WhatsApp messages which were exchanged, asking them to comply with their obligations. In the meantime, what happened was that we got to know from local sources that they were trying to create third-party interest in respect of the self-same property. The petitioner moved an application under section 9 before the Rajarhat Commercial Court. And then in pursuant to that application, there is an interim order which has been passed, which is subsisting as on date. Your lordship will find that order.
Interim order to do what?
Interim order to the effect of restraining them not to create any third-party rights of interest.
Date?
Order is dated, my lord, 7th of August, 2023, page 70. It starts from page 70. The operative part is page 76.
Very well. So that remains, according to you.
Yes. So now thereafter, section 21 notice is 22nd August 2023 is at page 77. There's been no reply to the section 21 notice. My claim will be on account of specific performance and also additional monetary claims which will be. The total value of the property is 1 crore 72 lakhs as per the agreement.
Yes, Mr. Mitra, what is your objection?
When the matter was first taken up, we had an issue of stamping, which is now gone. Whatever, if at all it gets referred to arbitration. This was also the matter, your ladyship may recall, there was a fight between us whether we had reached out for a settlement or not. That is not working out because on his police complaint, my client is incarcerated at present. But my lord, I'm left with, my lord, two technical objections to this petition. First of all, my lord, it has been filed in the commercial division. It's a residential property. My lord, this perceived, my lord, priority that is accorded to commercial matters should not be as a matter of course in the sense of taken advantage of by a litigant. Because this is a residential premises, and I'll show your ladyship the pleading
on which they attract the commercial division jurisdiction. It shouldn't be filed on the commercial side. But more importantly, kindly come to page 77.
Yes.
This is the section
21 notice.
21. Now, my lord, because my client is incarcerated, I've not been able to take proper instructions, but what I noticed from what is disclosed, and kindly come to page 79. The date is, kindly come, note the date at page 77, it's August 22. Now, kindly come to page 79. Your lord, ladyship will see 5 several postal acknowledgements. This is posting. Kindly see the third line of each posted on 23/8. Ladyship has that?
Yes.
Now, my lord, kindly see in the name of receipt and service what they disclose at pages 80 and 81. My lord, we'll see at the top right hand corner is the first of my clients, 7/8/2023, and there's a written endorsement of a receipt on 9/8/2023, which is an impossibility. Likewise, at page 81, identical. So, my lord, this is not the service. I'm not saying it wasn't served because I'm being candid. I've not been able to take instructions. But this definitely is not the service of the 21. Without the service of the 21, or without proving service rather,
30 days, 11
30 days, 11/6 can't kick in. So, my lord, either they clarify, I will also try and take instructions, but on their complaint, my client is in jail. So, the settlement has totally failed. There is a dispute, undoubtedly. But, my lord, these are the two objections. And, my lord, kindly on the first point that I raised, kindly come to, my lord, the pleading of commercial at page 4. This is the only pleading in the petition. Subparagraph E at page 4. Kindly see, my lord. There was a tenancy which was granted on the ground floor. It's a 2-storied premises, primarily residential. A small shop, a medical shop, is being operated on the ground floor. Now, my lord, kindly see how they attract commercial division after Annexure C is mentioned. Kindly read that line.
Yes.
As would be evident from the sanctioned building plan in respect of the suit property, the same is to be used for commercial purpose. As a matter of fact, from what has been stated herein above, it is evident that the suit property is being used for commercial purpose presently. Now, my lord, wrong on several counts. First, my lord, the sanctioned building plan does not say it is commercial. Kindly take page 67 first. This is, my lord, a challan that was deposited by my clients. Kindly have a look at this. This is issued to the Urban Development Department. Your lordship will see in the second set of headings. I'm so sorry. Ladyship has that?
67.
That's right.
Yes.
This is there an extra G. In the middle, your lordship will see address is IA 269, the second set.
Yes.
Kindly see the bottom, the third set of headings, IA 269, residential processing fees. Now, kindly come to what they've annexed as the sanction plan. Kindly come straight away to page 42.
Yes.
I did not, I'll be corrected by Mr. Bhattacharya if he points out the word commercial. I have not been able to locate it. Kindly come to page 42. Ladyship will see this is layout for bedroom, and one shop on the ground floor. So, my lord, that commercial, if at all, is restricted only to that one solitary shop room, that too on the ground floor. Everything else is residential. Also, kindly have a look at page 51. This is the agreement on the basis of which my learned friend sues today. Ladyship has page 51. Now, kindly see, this is the narration. It starts, my lord, I'm so sorry. It starts at page, my lord, 50. Kindly come to page 51.
Yes.
Kindly see how my clients are described. Miss so-and-so, having pan so-and-so, age so-and-so, daughter so-and-so, occupation so-and-so, religion so-and-so. After 5 lines, resident of IA 269. And it's nobody's case that this was not a residential property. Even my predecessor, my father, my deceased father used to reside there. I reside there. I have other houses, but I also reside there. It's a residential. My lord, this, as I said, my lord, ladyship will not take me amiss, but this perceived priority should not be taken advantage of simply for the asking. Residential property, assignment of lease, no commercial aspect, and it's filed in the commercial division. And my lord, of course, the section 21 is something that they would have to clarify. If they can prove service, my lord, I'm happy to
Yes,
waive
Mr.
that.
Bhattacharya.
My lord, in respect of the commercial division aspect, since I have filed a section 9 application before the commercial court rather, where they have not taken this point, they are not contesting the same. In fact, the point of jurisdiction has been taken.
Next point.
My lord, the secondly, my lord, in respect of the service, my lord, that I have to take instruction, but it's not possibly Mr. Mitro's case that he has not received the notices, because that point would have been taken on the first day. That point was never taken earlier.
Very well. I need to see that the 21 was served.
Was served. Very well. My lord, that I will take instructions.
And
because
the fact that you have filed it before the commercial court at Rajarhat is not a ground why you would file it before the commercial division here.
my lord, I'll have to, because since it's a commercial court, I filed it as a commercial matter. And my lord, therefore, my lord, this section 11 also I had to
No,
possibly
because
file it.
there is nothing, I don't see any commercial flavor in the matter.
Well, this is being the
Rajarhat court may have been under some impression that it's a commercial.
it was being there substantially used for commercial purpose. I've also
Very well. I think you should, you don't have a case under either of the heads,
in
but I will
respect
give
of
you time to come back with
service, yes,
instructions. Learned counsel appearing for the petitioner has taken the court through the relevant facts and documents to show that there is an arbitration agreement between the parties, as well as disputes which are required to be settled by an arbitrator. Stop. Next, learned counsel appearing for the respondents, sorry, takes 2 points, objects to the petition on 2 points, semicolon, namely, comma, that the petition could not have been filed, that the petition does not involve any commercial aspect or any grounds under section 2 within brackets 1 within brackets small c of the Commercial Courts Act, 2015, and also that the petitioner has not provided any evidence, also that the petition does not disclose, petition does not disclose any evidence of service of the section 21 notice on the respondent. Stop. Next, both these grounds require further consideration. Stop. Next, list this matter on.
any day convenient to lodge next week. Any day.
Agree on a date. If not on a settlement, at least on a date.
10th. No, him and I will agree.
Yes. List this matter on 10th January 2024 as well.
Mrs. Power Mold Daman.
I'm appealing for the applicant, madam. But in
Yes.
view of the contract made on 4th,
Microphone, please. Yes.
madam.
Yes.
But in view of the contract, my lord, a purchase order was made as page 26, my lord, of the petition, my lord, wherein they were intended to supply. But this is supply of.
Microphone, please. Microphone.
But
Yes.
it's not working.
Yes.
My lord. My lord, they have made contract to supply the heat for brake gear buses for BMBC for item quality for.
They as in?
Means the railway authority, my lord.
The railway will supply to you.
The respondent, my lord. The respondent authority.
The railway will supply to you.
No. But petitioner is
So
to
why
supply.
They.
The petitioner is to supply the brake gear buses. The quantity was 782. Out of which 391 set of buses was supplied to the respondent, my lord, on 22nd June 2022. And they have received the same. But when the payment was not made, and they want to make the payment is lower rate, which is at page 38. But we disputed this, and immediately section 21 notice has been sent to the respondent, my lord, which is at page 41 of this petition. since there is the arbitration clause which I have annexed in page 57 of this petition, but according to this, my lord, after giving page 57, page 57.
Yes.
My lord, since my lord, I have handed over my lord, the IRS condition to a lordship, my lord, yesterday. But now, my lord, pursuant to this letter, they have appointed an arbitrator from the State Department.
Yes.
Then, State Department, then petitioner send a letter dated 5th December 2022 at page 53 of this petition, my lord, stating that they appoint an arbitrator except the State Department, since the dispute between the State Department for not giving the price which was quoted at the time of agreement, my lord. Page 53, my lord, can you see the page 53? My letter dated December 5th, 2022. So, my lord, we requested them to make appointment any arbitrator, but except from the State Department, my lord. So, my lord, now yesterday my learned friend submitted the names of the person except the State Department to appoint arbitrator, my lord.
What is your claim?
My claim is 8 lakhs and odd, but this claim is 8,61,683.
Yes, Mr. Lahiri.
They've accepted an appointment of an arbitrator from the railways, which will not be from the store department, from any other department. My lord, they appoints anyone.
And your letter before page 53 is at page 52.
52.
Over there, what have you said? That you can't, what is the stand taken?
We have taken the stand. We have appointed a person as a conciliator, and we have said that the amount payable is 2,28,540, not 8,61,000 as claimed.
No, this letter is to the arbitrator. Where is your letter to the petitioner? Page 52 is to the arbitrator.
But, copy for information, my lord, last. But page 51 is also there, my lord.
Copy for information is to your persons.
To power mold at my lord, 3, item number 3.
Yes.
Yes, 51 is by the arbitrator to the petitioner.
My lord, the conciliator.
So you're identifying yourself with the conciliator. Cannot be done. Yes, the dispute between the parties arises out of a contract of an agreement dated 1st March 2022 for supply of certain equipments by the petitioner to the respondent in agreed quantities. Stop. This agreement contains an arbitration clause which further provides that the arbitration the disputes and differences will be dealt with as per the arbitration clause of the IRS capitals conditions of contract as amended from time to time. Stop. Next, the dispute, in essence, is of the petitioner claiming an amount of approximately rupees 8.61 crores.
Lakhs, my lord, lakhs.
Lakhs on account of the material supplied. Stop. The petitioner, through learned counsel, states that the respondent failed to pay for the equipment which the equipment supplied by the petitioner to the respondent. Stop. It is also submitted that the respondent requested for a lower rate of payment, which the petitioner did not accede to. Stop. Next, learned counsel appearing for the respondent. Respondents / Eastern Railway, comma, Eastern Railway, comma, submits that the petitioner agreed to appointment of an arbitrator other than from the railways department other than the stores, capital S, stores department. Stop. Council places a letter written by the petitioner on 5th December 2022 in this regard. Stop. Next, the admitted fact is that the petitioner invoked the arbitration clause in the agreement on 19th August 2022. Is that correct?
Correct.
19th August 2022. Stop. The only question which remains is whether the petitioner is whether the letter of 5th December 2022 written by the petitioner to the respondent can be taken as a waiver, WAIVER, waiver of the appointment of the arbitrator, who is admittedly, who is this arbitrator? This Mukul something?
Mukul Mohan is the deputy chief materials manager. He is not the arbitrator. He is one Amjad Khan.
Yes. Who is he?
He is the CMM.
What is CMM?
Chief material manager.
Working now.
Working.
Is whether the is whether the respondent's choice of arbitrator কি বললাম sentence টা? Whether the respondent's subsequent choice of arbitrator, who is presently serving as the chief materials manager, capitals, comma, would be a valid appointment under the provisions of the 1996 Act. Stop. Next. This court is not inclined to accept the respondent's choice of arbitrator. Stop. The person concerned is a serving official, officer, capital O, of the respondent, and the petitioner's letter of 5th December 2022 makes it evident that the petitioner agreed to settle for an arbitrator, comma, who was not a part of the stores department, capital S, capital D, comma, under some sort of duress. Stop. In any event, comma, the arbitrator, in any event, comma, the settled, in any event, comma, the law as settled by the Supreme Court and the High Courts, comma, preclude appointment of an arbitrator who is a serving officer of the respondent, comma, regardless of the department in which the arbitrator is presently engaged in. Stop. Next, considering the fact that there is a dispute between the parties which is relatable to the arbitration clause, comma, AP 751 of 2023 is accordingly allowed and disposed of by appointing blank. Paragraph to be communicated by 6 January 2024.
Oblige me.
11, Sunil Kumar Saw.
And I'm seeking an accommodation in this matter for next week, my lord.
I would be praying for vacating of the interim order. Because,
Sorry?
my lord, the section 21 notice was issued after a period of 90 days from, my lord, the day when they obtained the interim order.
You can't wait till next week.
If my
Because
learned
service
friend
was
has
not done, but I suddenly got information yesterday night, my lord. I would
Yes,
like to make allegations, that's why I wanted only said.
give me a date, Mr. Ray.
Tuesday, Wednesday, any day, my lord, your lordship.
What is the order which you have which you are
And,
suffering?
well, we have an order where, my lord, the accounts of the company, my lord, or rather the partnership, my lord, are to be given to the receiver and to be also placed before my client, my lord. It's in a partnership dispute, my lord.
Yes.
My learned friends also filed a suit. And I'll bring everything under before your
Very
lordship.
well. Tell me, you said Tuesday, Wednesday, so that's 9th or 10th. Tell me, Mr. Bhattacharya, which
Any day.
lists this matter on 9th January 2024 as prayed for.
Very grateful.
On behalf of the petitioner.
Very grateful.
Item number 12, Cholamandalam Investment and Finance Company.
Lord, this is my application under section 9 of the Arbitration and Conciliation Act, my lord. Lord, affidavits are complete in this matter.
You're enjoying an order.
But there is no interim order in our favor.
And who was appearing for the respondent?
Mr. Ramesh Chandra Prushti, my lord, was appearing for the respondent.
Very well. Last time it's 18th October. You tell me a date, Mr. Shortcut. I will, so that you can inform counsel and you can both come back. Give me a date, please.
Tuesday, my lord, coming Tuesday.
No one appears for the respondent. Stop. Since the matter was heard last on 18th October 2023, the advocate record of the petitioner shall communicate this order on the respondent. Stop. Aage actor line likho. List this matter on when did you say?
Tuesday, 9th.
On 9th January 2024 as paid for. Stop. Tarpore line ta likho.
I'm grateful.
Counsel submits that affidavits are complete in the matter.
Item number 13, Prosenjit Chatterjee and Messrs. Torun Kanti Chowdhury.
My application under section 11. But slightly different on facts, not a usual section 11 in the sense, my lord, there
First
has
time? First.
No, my lord, this pleadings
Heard
are complete. Your lordship has heard
Very
my learned friend made their submission on the last occasion.
No, what was the point?
Point is this, my lord, there was an earlier arbitration proceeding where, my lord, except one particular claim, all other claims were rejected. And in the section 34 was
you were the claimant.
I was the claimant. My lord.
Yes.
And in the section 34 proceeding, my lord, that award was set aside on the ground that it was not with reasons. There was no reason.
So Mr. Ray applied for setting aside of the award.
So I applied because the claims were disallowed.
Very well. Yes.
All the claims were disallowed except one particular claim, and they were disallowed without any reason, and on that ground itself the award was set aside.
Yes.
So my point was that that's now they have preferred an appeal. I have been served now with a memorandum of appeal. Now, my lord,
So why do you want a fresh appointment?
Yes, because the point is, firstly, mere pendency of appeal is not a stay. Secondly, my lord, once the award has been set aside, the list revives. The disputes which have been raised in the 21 notice have not come to its logical conclusion.
But an appeal will not put the matters at large once again.
No, that is the point, my lord, which I will argue. The appeal is there. It is neither here nor there.
They have not moved it. It's only a memo of appeal. That will not result in suspension of rights of the other party for all times to come. Because
So you want to file a fresh set of claims before a
I
different
want to
arbitrator?
file the fresh claims, same claims which have not been adjudicated on merit. And it has been, now it's large. It is still a list which is pending between the parties.
So the award was set aside at your instance?
Yes. Because it was there was no reason, it was not on merit.
Yes.
So therefore, my lord, my application under section 11, that the disputes remain, disputes are yet to be adjudicated, and within these strict contours of the jurisdiction of the section 11 court, nothing else apart from that is required to be gone into. Whether the claims will be barred because of appeal or not, that is a part to the claims being adjudicated. It's like a point of res judicata or similar analogous point. That is not with regard to, it is like, my lord, I have filed a fresh suit. And whether those claims will be barred.
Yes, you have filed a fresh suit after dismissal of an earlier suit at your instance.
Yes. And not on merit.
Why not on merit?
Because here the arbitrator, it is not that the arbitrator has pronounced on merit, and the section 34 court has simpliciter said that the award cannot be looked into it like this. Award cannot be looked into because there is no reason. So therefore, there is no opinion expressed by any earlier forum, one way or the other. This is the issue. And in reply, my learned friend cited one judgment on the principle of section 43(4) of the Arbitration Act, plea of limitation, that I am entitled to exclusion of the period during which a matter is pending in a higher forum, and I will get exclusion till the highest forum decides it. That is their principle. With the greatest of respect, a plea of limitation is different from, limitation says what? That beyond a certain period, I am barred from filing a claim. Today, I am not on the question of limitation. I am saying my cause of action is there. Therefore, even if your appeal is pending or it is not pending, my cause of action is still there.
Yes.
Even it's not pending. So that is what I am saying, that section 43(4) will have nothing to do with the my cause of action surviving. And at any stage before expiry of the limitation period, I can come to court. 43(4)
sets a limit of till the award is set aside.
And before the higher forum,
Why it shows that my main point was different. I think first point which was cited. Yes, cited because you are making a comprehensive submission. But first point was section 11 was not maintainable because he has no section 21 notice. He says it's a continuation on the list, and there is no 11(2) valid because he himself says that the arbitration agreement contained between the parties is not enforceable. If he says that, then he has to issue a notice for that 30 days period. I'm not aware as to which part of the statement that they have agreed with the entirety. But the problem not agreeing to that's a claim with them to raising it. What that they have to number for my agreement. That I don't find.
So that they have to go back to 11.5.
Yes, they have to. That is a must. That is not there. That is my initial
That
point.
is also under section 15(2).
Well, this may not be 15(2) with humanitarian submit.
No, not a substitute arbitrator, but also 15(2) also refers to the proceedings which were there originally.
With humility, may I say this, here the proceeding has terminated. In that case, the mandate
substitute arbitrator.
That's a mandate termination of the arbitrator. Here, the proceeding has terminated. They are entitled to de novo. But the difference between suit and this is because, your lordships, in suit and appeal can give a fresh reasoning. But your lordships in the Supreme Court, now they have said that you can either set it aside or you can keep it. So that is the only reason why we can go back. In a suit, we cannot go back, Manu. That would have been great for us, but we cannot. But these are the main 2 points. After that, we have taken the point of section 43 also, that when it will revive, because it's a continuation of the list. 34, then 37, and then whatever it is. Now, kindly consider as well. Let us say 37 is allowed. Then what happens? And let's say by that time 37 is allowed.
37 means your appeal from the decision setting aside the award.
Yes, ma'am.
Yes.
Because that will reach
So if that is set aside, if you
that is
succeed,
allowed.
then the award comes back.
Award comes back. Then in the meantime, another arbitration.
Yes.
And my first point is there is no section 11 notice.
And Mr. Sen said that is for the same claims, not for a fresh.
Now he's saying that. I mean, the principle, general principle.
Yes.
Today, someone comes back from an unreasoned award. It may be that I concede to a few.
Yes.
And a few I do not concede. So the disputes, I have to be noticed that these are the disputes now.
Yes.
That is not there. But I'm not on this matter, kindly matter. So, that notice is not there. That is the fresh section 21 notice required. And thereafter, then since they say that this is not the same arbitration agreement, I'm not entitled to invoke that for, I believe, tough and other things. In that even, they will have to issue a notice for section 11. That is not there. These are my 2 preliminary submissions. After that, I'll make submission of the merits. I've given the judgment only to show that it will be a continuation.
Judgment on?
Section 43.
43.4.
To interpret the word setting aside,
I thought that was the main point argued.
But this is the...
But Mr. Sen, whatever be the case, you first have to address the court on the section 21 notice.
Yes. Your Lordship,
Without a section 21 notice,
yes.
whether you can maintain the present
Now,
action at all.
kindly see the section 21, my lord.
How much time will you take, Mr. Sen?
10 minutes at least.
কখন থেকে আছে চেম্বার গুলো?
12টা.
10 minutes. You just indicate your point and you have to come back on some
my
other day.
first point is section 21, why it is not necessary in this case. Unless otherwise agreed, arbitral proceeding in respect of a particular dispute commence. So my proceedings have commenced by my notice. On the basis of that notice, the disputes are enumerated. There was an award which has been set aside. Disputes have not come to an end. It is not a fresh cause of action. It is not like I am having a separate cause of action distinct from the earlier proceedings. It is saying particular dispute in respect of a particular dispute commence. But I could have understood my learned friend's submission if my case is based on, say, subsequent accrual of facts, giving me even a minuscule percent of a new cause of action. Then it will not amount to the same 21 notice being revived.
Yes.
But a provision in the statute has to be interpreted having regard to the context. It does not say for the same dispute, I will have to raise several notices.
Very well. Mr. Sen, if it is the same dispute,
yes,
then what happens if Mr. Ray's client is successful in the appeal?
Then they will have a cause of action to take before the present reference which will commence. I am on a section 11 court. What is the nature? I have a complete answer to your lordship's query, but let me explain in my own way.
Yes.
What is the parameters of exercise of jurisdiction of a section 11 court? Section 11 court is not going to entertain an objection as to the tenability of the claims. What is this nature of this objection? That
in case the appeal is allowed in their favor, my claims cannot be adjudicated again. It is akin to a principle of res judicata. Now, therefore, begs the question whether a plea of claims being barred by res judicata can be raised while resisting a Section 11 application. That goes directly to the merits of the claim. That my claim is becoming barred because of a subsequent event of the appeal being allowed.
But Mr. Sen, when we consider objections to limitation, is that also not on merits then?
No, here Malad, there is an Lordship will see in one of those judgments, Malad, I exactly do not remember, either BSNL, Nautel or Purvanchal, where it makes a distinction between admissibility of the claim and the jurisdictional issue. And while discussing limitation, limitation is also not a point where the court under Section 11 can readily go into. There also, the jurisdiction of the court is only to that extent that you will have to show on the face of it that it is ex facie barred. But if there is some sort of a doubt, then the court cannot go into that claim, because a plea of limitation is not strictly a jurisdictional claim. It is an admissible claim, admissibility. Claims are not admissible. That is because of the nature of limitation. In some cases, it is a case of mixed question of law and fact. And only when one satisfies the court to the hilt without looking at anything else that it is barred by limitation, it is only an exceptional situation where the Section 11 court can go into. So therefore, my lord, the plea of res judicata, that there are judgments also, that the plea of res judicata cannot be gone into by a Section 11 court. So this is a plea which is, in my most respectful submission, which will come beyond the contours, the limited contours of jurisdiction of a Section 11 court. That if the appeal succeeds, then what happens? But kindly consider from the other point of view. You will take that point before the arbitrator.
So your second point is related to your first point, is
Yes.
that you are not required to give us fresh Section 21 notice.
Yes.
Because according to you, it's a continuation of
Continuation of the same claim.
and therefore also 43.4, Section 43.4. Or is that a different point?
43.4, allowed with my great respectful submission, cannot apply at all. Because kindly see, 43, what is the meaning of 43.4? 43.4 is when you can exclude the period for the point of view.
You want to leave or you want to say something?
I only feel that I think I have not been able to explain the 43.4 because we are now going up a different red herring. But if I may explain, but I have not taken the point of limitation by showing 43.4.
That I understood. That I think
I am sure
that my learned friend.
What I want to say is, Malad, I have only tried to show
that you have to wait till the last forum decides it.
2 words only. Malad, there it says, Malad, first it says, Malad, 43, Malad, where the court orders an arbitral will be set aside. The period between the commencement of the arbitration date of order of the court shall be excluded completing time prescribed the limitation period. Till this, Malad, is limitation. Then the part which I am relying upon. For the commencement of the proceedings, not the continuation. For the commencement of the proceedings, in brackets, including arbitration, with respect to the dispute so submitted. There is a fresh dispute to be submitted. That will commence. And if you want to go into arbitration, Malad, Section 21 is the only place which says commencement of proceedings. This is what I wanted.
No, this is a general.
Very well. Mr. Sen, you tell me when you want
Just
to come.
one line, my lord. This
Yes.
is a very general proposition with regard to principle of proceedings being excluded, analogous to Section 14 of the Limitation Act.
For the purpose of limitation.
For the purpose of limitation, for the purpose of when I am going to institute a new proceeding, am I entitled to the exclusion of
Provided the award is set aside.
provided the award is set aside. It does not say, but kindly see, limitation is a bar against institution of proceedings beyond a time. But cause of action and limitation period is different. Today my cause of action arises. I can come to court tomorrow. I can wait till the last day. And if I wait till the last day, I will have to show the period is still there. So limitation
Very well.
is
I've
a
understood
bar,
your point.
cause of action is a right.
Yes. Mr. Sen, I will do this. I will first hear Mr. Ray,
Very
so
well.
that it helps you. It helps you. You will understand what exactly Mr. Ray's objections are, and then you can give your response. Otherwise, we will just go on in around in circles. Yes, Mr. Ray, when do you want to come back? 10th.
10th one. My lady, please.
Yes. A learned counsel appearing for the respondent has taken two objections on the maintainability of the petition for appointment of an arbitrator. Stop. The first is that the petition cannot be maintained without a notice under Section 21 of the 1996 Act. And the second is the uncertainty involved in the event the respondent succeeds in the appeal filed from the order dismissing order setting aside the award. Stop. The application for setting aside of the award under Section 34 was filed by the petitioner, who was the claimant in the arbitration, on the ground that most of the petitioner's claims were rejected by the learned arbitrator, by the tribunal, more than one,
Sole arbitrator.
by the learned arbitrator. Stop. Next, after hearing learned counsel, this court is of the view that the arguments would be better served if the respondent is heard first on the objections raised. Stop. Next, Lysis matter on, you said 9th?
10th.
Lysis matter on 10th January 2024 as paid for.
I had a third point, Your Lordship, if I may be going to take it then, Manat, that there is no notice under Section 11(5) also. But that I don't think has gone down. Manat, kindly allow me to take the point.
Very well. Yes, yes, of course.
Very good.
Yes. Any other matters where before I call on the chamber matters? Orator Dakota.
Item number 14, Zillion Infra Projects.
My lord, I appear for the petitioner, my lord. There is a
Yes.
Section 11 application. My lord, my learned friend has raised an objection that there is no arbitration clause. Therefore, my lord, I need to, my lord, address your lordship, my lord, on the clause itself.
No, Mr. Gupta, what was your objection based on? There's no arbitration clause.
There's no arbitration.
And what is the document you have relied on for that?
Page,
Microphone, please.
I'm sorry. It will be page, the document starts at page 314, and the relevant
Which
part
volume? Which volume is that?
my lord, volume 3, my lord, of the petition, my lord. My lord, and the relevant portion is, my lord, 317. Yes,
Which clause?
Lord, 14.
Why do you say there is no arbitration?
Lord, may I just indicate, my lord, IOC had given me a bigger contract, my lord. I had made
IOC?
IOCL, my lord. IOCL had given
Not
me
a party before court.
no, not a party before.
Say that, please. Yes.
IOCL had given me a bigger contract. I had divided into subcontracts, and one of the subcontracts was given to the petitioner, my lord.
Yes.
Now, my lord, the contract between myself and IOCL has the arbitration clause. And I said that all the general and the specific special terms of the contract between me and IOCL will be applicable. except for, my lord, certain specific terms, my lord, which is your lordship, the document which I am referring to. Now, my lord, clause 14 says the arbitration of disputes, if any, between IOCL and Bridge and Roof will be final and binding upon the subcontractor, my learned friend's client. No dispute can be adjudicated separately through arbitration or any other similar forum for any disputes between the subcontractor and Bridge and Roof.
Yes.
However, in case subcontractor desires Bridge and Roof to raise certain disputes pertaining to its claim for reference to arbitration, the subcontractor shall approach Bridge and Roof with such requests substantiating its claim, and in case Bridge and Roof feels justified to initiate an arbitration, the arbitration may be the arbitration may be invoked by Bridge and Roof with IOCL. So, my lord, if the petitioner is aggrieved by certain actions of IOCL, my lord, he will approach me with documents and substantiated claims, and then I shall approach IOCL for an arbitration. But, my lord, the second line is very important in this clause, my lord, which I'll once again repeat: no disputes can be adjudicated separately through the arbitration or any other similar
Very well.
forum.
I've understood. Yes,
So
that was your objection.
That
Yes.
was my.
Mr. Dotto, not a very long argument. Just tell me your response to this.
First is, my lord, this is an arbitration clause. There is no dispute on that. What is sought to be pointed out is that the mechanism in the arbitration clause is such that I don't have a right to invoke the arbitration clause. This is
separate arbitration.
Yes, this is what is sought to be, my lord, argued before this court. Now, my lord, please have a relook to, my lord, this clause once again.
Yes.
One cannot dispute that this is an arbitration clause.
Yes.
Now, if there is an arbitration clause, my lord, I don't think, my lord, I need to address your lordship on anything else, because the court will only look into whether there is an arbitration clause or not.
Yes.
Now, so far as the mechanism is concerned, my lord, I don't think, my lord, in a 11-6 proceeding, my lord, I need to address your lordship on the mechanism. But still then, my lord, to satisfy the conscience of the court, I'll, my lord, address your lordship on the mechanism. Now, please take, my lord, my learned friend is harping on the second sentence, on the second line, that is, no dispute can be adjudicated separately through arbitration or any other similar forum for disputes between the subcontractor and BR. I'm the subcontractor. Then what happens is, however,
yes,
this is a clarification or non-obstante, if I may say so. However, in case the subcontractor desires B&R to raise certain dispute pertaining to its claim means the subcontractor's claim. For reference to arbitration, the subcontractor shall approach B&R with such request substantiating its claim. And in case B&R feels justified to initiate an arbitration, decision of the concerned general manager of B&R in this regard will be final and binding. The arbitration may be invoked by the B&R with IOCL, and the decision of the arbitrator will be final and binding for the subcontractor of all disputes. However, the subcontractor has to bear, etc. So therefore, my lord, it is not that there is no arbitration clause. It is not that I cannot get my claims adjudicated. But what is the clause? The clause is that my adjudication is at the vagaries of B&R. Therefore, my lord, there is an arbitration clause. And this arbitration clause also, my lord, provides for, my lord, adjudication of my claim vis-a-vis B&R, not IOCL. Now, the mechanism provided is that B&R will first satisfy itself that is there any claim? Is there any justified claim? If it is satisfied that yes, there is a justified claim, then there will be an arbitration between IOCL and B&R, and whatever is decided over there is binding on me.
Yes.
Now, my lord, these kinds of clauses, or my lord, these kinds of precondition that I have to first satisfy B&R, and thereafter, if required, everything will be done. This has, my lord, fallen for consideration before the Honorable Court in a very recent judgment, where, my lord, the preconditions in an arbitration clause, if they are found to be contrary to Article 14, this is very important. Article 14, my lord, has been, my lord, incorporated now. In that case, the doctrine of severability will apply. Severe, these are all in section 11 proceeding. The Supreme Court has said this. Sever the bad part and appoint the arbitrator. I say which part is to be severed or which part is bad, that I have to wait for the vagaries of at the mercy of BNR. This is a very recent judgment of a 3-judge bench of the Supreme Court in an application under section 11, where, my lord, there were 2 conditions, not as onerous is mine. The first condition was that if you want to invoke arbitration clause, you have to have a pre-deposit of 7% of your claim. This was one of the clauses, conditions in the arbitration clause. The second condition was that the principal secretary of the department concerned will appoint the arbitrator. Now, these 2 parts, the Supreme Court felt that these are unconscionable, arbitrary, and, my lord, therefore, these parts were severed. My lord, they have relied upon a 9-judge bench of Supreme Court of Canada and have, my lord, borrowed that principle and applied over here and severed it. Therefore, my lord, this is a case, my lord, where I respectfully submit, my lord, that this portion which says that in case BNR feels justified to initiate an arbitration, then there will be an arbitration between ICL and BR. This part, my lord, in my very respectful submission, needs to be, my lord, severed, my lord, from the arbitration clause. And in that, if your lordship reads this without the clause, without the bracket, then I have an arbitration remedy. Or the clause is there. It's not that the clause is not there. Now, if the clause becomes unworkable for me, onerous for me, unconscionable for me, my lord, here, my lord, the Supreme Court has laid down the law under Article 141 that the Section 11 court can sever it. Well, if your lordship may kindly permit me to place this judgment, this is a lengthy judgment, which is reported in 2023.
2022.
23.
Yes.
2023 SCC online SC 1422.
Mr. Doctor, I will go into that. I will of course see the judgment, but please consider that there are 2 judgments.
Yes, madam.
One by Justice Ravindran,
Yes.
which is I think very clear, and as are all of Justice Ravindran's judgments, extremely very good judgments.
Yes, madam.
That's 2007 5 SCC 719. That's Jagdish Chandra. And I think, I don't know whether that has been followed or not, but there is a more recent judgment of the Supreme Court in 2011, which is some Velusamy or something. KK Velusamy. VELUSAMY, I think. That's of 2011, but on the same point. So, and these 2 judgments, but more the first one of Justice Ravindran, when there cannot be a valid arbitration clause, or when an arbitration clause will not, what is the benchmark of that? Just go through the judgments, and of course, I will consider whichever judgment you're. This is, and this judgment, Lombardy, yes, I've read this. Lombardy, as far as I remember, Lombardy presumed the existence of an arbitration clause.
But that quoted the arbitration
Justice Pardiwala
clause.
presumed existence of an arbitration clause. But anyway, you please come back and tell me when you want to.
But next week, anytime, except Thursday.
Except Thursday?
10th, I will be in some difficulty.
So tell me when you want to come back, Mr.
Any day,
both of you?
10th, except 10th and
10th, 11th. Tuesday, 9th?
Tuesday, yes. Tuesday is all right, Mr. Gupta? Learned counsel appearing for the respondent has taken an objection as to the existence of the arbitration clause. Stop. Counsel has placed the relevant clause to say that the arbitration clause does not contemplate any separate arbitration between the respondent contractor and the petitioner subcontractor. Stop. The arbitration, comma, if any or at all, comma, is only to be between the respondent contractor and IOCL, comma, the principal. Stop. PAL, principal. Stop. Next, Lysis matter. On Tuesday, you said? On 9 January 2023, 2024 to hear learned counsel appearing for the petitioner.
I'm grateful.
Call on the chamber matters.
New chamber matters. Item number 45, Fort Investment DMCC.
So this is my execution of foreign award. On the last occasion, my lord, the respondents' opportunity to place their case has been closed, and they were directed to furnish costs. I do not think, my lord, because we have not been intimated as to whether they've paid the costs.
Cost
That as it
for
may,
what?
For having sought an adjournment time and taken time on more than occasion. Now, my lord, may I just proceed with my execution because, my lord, their opportunity stands closed.
Opportunity of?
Of making submissions. Well, I believe the order record, so I'm not deciding anything.
But I'll just indicate, we had sought for an adjournment. I was,
Microphone, please.
I was
Yes.
not there that day. An adjournment was sought. Mr. Ghosh opposed it. He wanted a copy of the judgments which we had indicated we'll serve it in prior to the address, Your Lordship, on that. We had not given him the judgment. Now, this appears to be something wrong with the mic.
No, I can hear you.
Oh, then.
Yes.
So a cost of 10,000 rupees was imposed. That cost, I'm told, we've not paid, but with the undertaking, they shall be paid today. There are judgments that we forwarded. Your Lordship desires, not we can place those judgments because after all,
Mr. Banerjee, after you pay the costs, I will hear you.
Your Lordship keeps it tomorrow on Thursday. My lord, today
Mr.
we'll
Ghosh,
pay
what
the-
do you have to say?
Well, let him pay the cost because
I'll pay the cost. That is not a concern. I'll pay the cost and come.
And Mr. Banerjee, that's why I looked at the order. This particular organization is for destitute children who are girl children. Yes, so please do that.
Certainly.
Yes. When will you come back?
Thursday. There was a direction to be paid
Thursday,
within 7 days. That's on 19th of December. I do not know why.
I'll pay him the interest outside court.
No, I'm not.
Mr. Banerjee, that's not the point. You should have done it.
My lord, from
That
what
to
we
be
are given to
compliant of order.
understand,
And the quantum is nothing. You should have paid that.
Orders of court have
without
to
a
be
doubt,
complied.
Yes.
without a doubt, Lordship keeps it on Thursday. It will be done today. My lord.
Yes. The respondent has not complied with the direction of the court dated 19 December 2023. Stop. Learned counsel appearing for the respondent undertakes to pay the costs by in the course of the day. Stop. Next. List this matter. On when do you want to come back?
The 9th? On 9th?
On 9th January 2024. Stop. And Mr. Banerjee, why has your advocate on record not complied with the direction?
But for payment of cost, I'm given to understand that you do not understand how to make the payment to this particular organization. That's what my instructions
So by
are.
26th, you were supposed to do it. Why are you making this submission on the 4th?
Lord, Lordship will just give me a minute. No? Huh?
The respondent will
We had
pay
called them up.
additional costs of 10,000 rupees, 10,000
So your Lordship will
for
not.
the delay in the compliance.
Lord, may I just
For the
only
delay in
indicate, may I just
compliance.
only indicate this. Lord, my instructions are that they wanted to find out the particulars for making payment. We should have mentioned it, but this was to be done. Your Lordship will not impose additional 10,000 rupees cost. I'm giving an undertaking that it should be done today. If it's not, I will pay the cost because the cost I've suffered on my ground. It's my undertaking is not done. I will
And
pay
the
the
last
cost.
advocate.
Lord, it's understood when the event they default below, their opportunity stands closed.
Definitely.
Lordship,
Yes.
kindly.
Yes.
Great.
Call on the next matter, please.
46, MSV Laboratories Private Limited.
I am for the judgment debtor. Last occasion direction was given me to file an affidavit. Affidavit is ready, but calculation has not been filed. Kindly give us a last
For what
chance.
calculation?
Calculation the interest. Last occasion.
Affidavit will contain the calculation. What will you calculate after filing the affidavit?
We have to annex that. My lord, direction was given last occasion. According to them, the appointing date, the first date of calculation. They have calculated from date of my lord bill. So we have prepared the calculation. Kindly next Thursday, meanwhile, I come with and calculations.
If anything
Yes.
we'll say, then my lord, next week.
Yes, learned counsel appearing for the award debtor seeks time to file the affidavit in opposition as was directed on 21st December 2023. Stop. Next. List this matter on 11th January 2024 as prayed for.
Item number 47, Mintech Global Private Limited versus Kesuram Industries.
My lord, this is the matter where, my lord, the
That
maintenance.
commercial courts,
Yes.
that statement of
Mine.
That's a minute on 2nd January, your lordships recorded that
Yes.
he has taken certain point on maintainability on the ground of Order 6, Rule 15A, 1, 4, and 5. So the execution case could not have been filed without complying with the requirement of the aforesaid provisions of the Commercial Codes Act.
Yes. And Mr. Bandobata, you had said that they did not take this point earlier.
At the initial stage, they have taken. Thereafter, the orders have been passed in these matters. But, let me just clarify the situation.
Yes.
First of all, your lordships kindly come to section 36 first of the Arbitration Act itself, where the time for making an application to set aside the arbitral award under section 34 has expired, then subject to the provisions of a subsection 2, such awards shall be enforced in accordance with the provisions of the Code of Civil Procedure 1908 in the same manner as if it were a degree of the code. Therefore, award will be executed by as a degree, nothing more than that. And degree is executed only under Order 21 of the Code of Civil Procedure.
Yes.
No other provisions of the Code of Civil Procedure would be applying.
Yes.
No other provisions of the Code of Civil. And how it will be Clause 21, Order 21, lordships kindly come to Order 21. Most important part is Order 21.
Yes.
This is Order 21 is execution of a degree and orders, payment under degree. Right, Miller? This is the whole mechanism has been fixed. Kindly come to 11, Clause 11, Subclause 2, written application. Save as otherwise provided by Subrule 1, every application for the execution of a degree shall be in writing, signed and verified by the applicant or by some other persons, proved to the satisfaction of the court. Proved to the satisfaction of the court to be acquainted with the facts of the case and shall contain in a tablet from the following particulars, namely, then the details have been given. Therefore, whose satisfaction is required? Satisfaction of the court is required, nothing more than that.
Yes.
My humble submission is Order 6 doesn't apply in case of execution at all. Order 21 is only applicable. Order 6 is not applying at all. Well, it has to be executed.
No, Mr. Bandobata, it's not a question of whether it's execution or not. It's a question of whether, whenever you're filing something in the commercial division, then the commercial court, the rules, that will have to be followed as given in the schedule of the 2015 Act. So definitely Order 21, Rule 11.2 will apply in case of executions, but whether you can completely bypass Order 6, Rule 15A.
Order 6, my submission would be Order 6 doesn't apply, including 15A. Not at all. Only applicability is, so far the requirements of concern, that's a different issue.
Yes.
I am coming to that. But the orders, so far the execution is concerned, only Order 21 is applicable. Order 6 is not applicable. Order 6 is applicable. Kindly come to Order 6. If that's so, Order 6, Order 6, what the 15A, your lordships, on the other
The statement of truth.
state. Is it the, what is the statement of truth? Where? Let's assume for the argument order 6 is applying. Where? Kindly come to me, Lord, order 6. What is rule 1? Pleading. What is pleading? Pleading means, pleading shall mean plain or written statement.
Yes.
Here is no plain or written statement, my lord. That stage is over. That stage is over in before the arbitral tribunal. Lord, the Commercial Courts Act itself does not prescribe any mechanism of the execution. When a dispute, original dispute is filed before the commercial court, then the Millard Order 6 would be applying. I mean, for deciding the right, for deciding the dispute itself. In an arbitration, Millard, effectively the commercial dispute has been decided in the arbitration itself. So far the execution is concerned, Millard, the other things would be applying. Commercial dispute is decided in a commercial court. When in a commercial court it is decided, then Millard Order 6 is fully applicable. Statement of truth, Millard, what is saying, Millard, this is clause requirement of this clause 15 itself. That stage is covered before the Millard, the arbitral tribunal. And see, Millard, just a minute. When the amendment has been made in the Commercial Courts Act, the amendment has been made. Effectively, what has happened on that date? This Commercial Court Bill has been passed.
Yes.
And thereafter, arbitration and a conciliation bill, amended bill has been passed. And that's the reason, Millard, kindly come. I will just clarify this part. Kindly come to Section 2, C 21E. How this has amended?
Of which
of the Arbitration Act. Millard, this is amended on the basis of arbitration and conciliation bill, not because of the Commercial Courts Bill. Of course, in the line of the Commercial Courts Act bill, but not on the, but itself Arbitration Act bill was passed, has been given, an act has been assent, and then the Millard Section 2C has come. 2E. 2E, your lordships will find there initially in 2E from 31st December 2015 to up to 2018. Up to 2018, there is no commercial division at all. This act itself has said, Millard, ordinary civil jurisdiction. And your lordships will find from when the bill was passed and even in the act itself, there is no commercial division. But how the commercial division has come? Commercial division has come because of, Millard, this is in 2018, the amendment was made, Commercial Appellate Division of High Courts Amendment Act 2018. Then the commercial division has come. Initially, it was not commercial division. 2015 to 2018, it is only original jurisdiction. Although commercial court has come, already act has come, court has started to function.
Yes.
Therefore, Millard, even in the arbitration itself, kindly see, in the Arbitration Act itself, in the line of the Commercial Courts Act is concerned, amendment has been made. But no amendment has been made so far Section 36 is concerned. If Section 36, no amendment has been made, then it has been kept as only for the purpose of the execution of the decree. Leave aside, Millard, Section 30, I am not on that. So for 36, this arbitral award has to be executed. Who will execute? Because the arbitral tribunal has no power. This power has been given to the High Court or the other courts principal of the courts to execute the decree. Then they are not deciding the dispute as such of a commercial dispute as, Millard, under Commercial Disputes Act itself. Original dispute is not being decided. Original dispute, in a case of deciding the original dispute, then Millard, Order 6 comes.
So according to you, Mr. Bandhavadhyay, what would be an original dispute? Only a commercial suit?
Original dispute, of course, the commercial suit. In a case of a commercial suit itself.
And what about a Section 9?
Section 9 is the
Of the
application.
Arbitration Act.
Arbitration application. I am talking about the dispute require. Dispute is decide the dispute. Who will decide the dispute? Original dispute. Original dispute, then the execution comes.
So you're saying that this is not required in a Section 9 or a Section 11, nothing?
But I have not applied my mind so far 911 is concerned. I am just
No, since you're saying original dispute.
So far Section 9 is concerned. Kindly come, Section 9. Orders, Section 9 to law.
Very well. Mr. Bandhavadhyay, you can think about it later. You tell me what you want.
Now, I am just giving my points.
Yes.
Interim measures, etc. by court, a party may before arbitral proceeding, it can come. Whether at this stage of interim relief is given, court is deciding the right. In a normal course of the principles regarding the interlocutory applications, granting the principles of interlocutory regarding the balance of convenience and etc. is applying. Not the court is entering into the original dispute. So, but original dispute is concerned. Original dispute, this court, commercial court as such, although arbitral proceeding, everything is covered by the commercial court. But original dispute is not being decided. That's the reason, kindly see Section 19 of the Arbitration Act itself. Section 19, kindly see Section 19 of the Arbitration Act. When original dispute is being decided. Similar. Section 19.
Yes.
19.1. The arbitral tribunal shall not be bound by the Code of Civil Procedure 19.8 or the Indian Evidence Act 1872. 2. Subject to this part, the parties are free to agree on the procedure to be followed by the arbitral tribunal in conducting its proceeding. 3. Failing any agreement referred to in subsection 2, the arbitral tribunal may, subject to this part, conduct the proceedings on the manner considered appropriate. 4. The power of the arbiter under subsection includes the power to determine the admissibility, relevance, and materiality and weight of any evidence. If this is the provision, then one can argue, then now why not Order 6 would apply? But consciously, Section 19 has been kept. Even after the Act has come into force or the amendment in 2018, Section 19 has not been changed. Only change is only under Section 2(1)(e). Statement of truth is not required to be placed before the arbitral tribunal. If this is the position, how Order 6 is applying? Order 6 speaks about first is plaint and the written statement. That's the claim and the counterclaim before the arbitral tribunal. If plaint and written statement is not there, how Section 50, Order 6 Rule 15 will apply? It's not applying at all. Let's assume, leave aside everything. Just I will write, just I'm formulating my point and leave aside everything. Leave aside this technicality. May I submit, say, highly technical point has been taken.
Not suspicious.
Not at all. It's a pure technical, nothing more than that. Orders, I have no doubt in my mind to submit, to make your submissions. The orders is not applying, only in so far execution is concerned, Order 21 is applying. Let us take it, Order 6 Rule 15 is applying. What is the wrong? What is the error? Let's come to the point. It's a trivial in nature, minor, very minor. Cause title. What has been written? Here, in affidavit is correctly done. So far the statement is concerned, they have said the original side instead of commercial division.
is a cause title, my lord. Affirmation is before the same person, oath commissioner. Only one oath commissioner is there, appointed by the High Court. So oath commissioner is affirming division, commercial division. Oath commissioner is affirming original site. Oath commissioner has also affirmed his application. There is no such lack of jurisdiction. Who is hearing? Same court. Original jurisdiction, commercial jurisdiction. Therefore, this court is not having a lack of jurisdiction. I can understand that no, other forum was there. I am forum hopper. It's not that. Same court. Same court. Maybe your lordship is in the commercial division, your lordship is sitting here. We have seen some judges, commercial division sitting in this courtroom, then my lord, in original jurisdiction goes to another courtroom. And I had a doubt in my mind why they changed the courtrooms are unnecessary. But your lordship is sitting here. If it is taken, is a purely commercial court. Why your lordship will take up any commercial original jurisdiction matter sitting here? This is a pure technical. Pure technical. And cause, what is the mistake? Mistake is in the cost title. Well, thousands of cases courts grants liberty. If the court is satisfied, you amend the cost title. In an appellate side, cost title is amended in court itself. In original side, if the court grants the leave, it has to be gone there. Nothing is more than that. Anyway, my lord, these points have been asked. Now, my lord, I just rely upon just 1 minute. I'm coming, sir, coming, sir. Let me, my lord, the non-human justice, non-human judgment account. Ask see down now. 2018-3. Just a second. See, my lord. 2018-3 SCC 622. Of course, we are spending time, but such a that is down.
What is the point of this?
The point is that order 21 would apply.
Says that commercial courts will not apply.
No. It has been decided. No, not the order 21. It says
This is not Justice Nariman. This is.
Oh, sorry. This is sorry, Chelamal sir, and sorry, Sanjay.
This is Justice Call's.
Nariman I have kept for others. Sorry, I am very sorry. Kindly see, my lord, here and say above paragraph 14. The aforesaid page 632. Kindly come to page 630.
Which paragraph?
My lord, above paragraph 15. It's continuing paragraph 14.
Yes.
We would now like to refer the enforcement. Right? Now, my lord, kindly come to that 636. The aforesaid provision would show that an award is to be enforced in accordance with the provisions of the said code in the same manner as if it were a decree. It is thus the enforcement mechanism which is akin to the enforcement of a decree. But the award itself is not a decree of the civil code. As no decree whatsoever passed by the civil code, it is thus the arbitral tribunal which renders an award, and the tribunal does not have the power of execution of a decree. For the purpose of execution of a decree, the award is to be enforced in the same manner as if it was a decree under the code. That is order 21. What is order 6? Order 6 gives the dispute, original dispute, right of the parties have to be decided. Original. Let's assume, let's take a case. If order 6 is applied, after the commercial court passes a decree, then again order 6 would apply. Leave aside arbitration. Or order 21 would apply. After going through the rigor of the order 6, all the provisions, commercial court passes a decree. Then when at the time of execution, again order 6 or order 21. If order 6 is not required at the time of the execution, order 21, in a case of arbitration, same thing.
Very well.
Despite
Mr.
the
Yes,
and
Mr.
Milord,
Bandapad, I've understood your point.
and Milord, there are 2 or 3 judgments regarding procedural and substantive law is concerned. Your lordships have already delivered a judgment. Milord, yes, Milord. This kindly see Appendix 1 to the Commercial Courts Act. Just a minute. Appendix 1, Statement of Truth.
Yes.
That is under first schedule. My lord has got it.
No, I have it. Yes.
See, my lord, under first schedule, order 6, rule 15A, and order 11, rule 3.
Yes.
Not under 21. This is order 6 rule. The deponent do hereby. Then, my lord, your lordship was talking, my lord, referring to 5 and 6. I say that all documents in my power, possession, control, or custody pertaining to the facts and circumstances of the proceeding initiated by me have been disclosed and copies thereof annexed with the plaint. Annexed with the plaint. That's in case of suit. See, and I do have no other document. All these documents have been placed before the arbitral tribunal. Verifications have been made. Then 6C, I say that above mentioned pleading comprised of a total of so and so page. Each of these has been duly signed by me. Now, my lord, kindly see your lordship's original side rules. Now,
Yes.
see, my lord, chapter, what is it? Chapter 6, 82. Chapter 16. 7. Chapter 17.
17.
Yes, my lord. Chapter 17, rule 10. This is a High Court's original side rules. High Court thought it fit not to amend. High Court has issued a directions under the Commercial Courts Act only in mid of October 2023. Similar, the application for execution, where the provisions of Order 21, Rule 22(2) of the Court apply or not, shall be in Form 1 and shall be on sheet of durable paper of good quality, full square size, and shall in addition to the particular mentioned in Order 21, Rule 11(2), which I have already placed to your lordships, not referred to Order 6. Milord, after all, Milord, whatever it may be,
yes,
Milord, that's a pure technical questions, hyper technical. Now, why should I say technical? I just remember our note ta kothay gelo? Just 1 minute, Milord. Kindly, Milord, there are the Milord 2020 volume, just I am giving the reference, Milord, that procedural justice will not, your lordship knows the substantive justice has to be done.
Yes.
Do a 2020 volume 10 SC 706 para 9. Para 9. It is often said that the procedure is the handmaid of justice.
Mr. I know all this.
My lord, your lordship knows, my lord, and your
No, no, no.
lordship's judgment is, my lord, 2021 SCC online 2457 Calcutta, page 17. Sorry, para 17.
That
Your
is-
lordship's judgment.
That is against you.
Absolutely in my favor. And I am sure that my lord cannot be, my lord, in favor of this striking the hyper technical question. But if I borrow your lordship's language, my lord, then it cannot be a speed breaker of the commercial court's function.
Paragraph?
Paragraph 17. জোসেফ বললো জানি যখন আমার কি দরকার আছে বলতে দরকার নেই
No, no. I am only familiar with the handmaidens part, not the other, not the rest.
Pardon me, sir? Yes, but no, your lordship has said if a purposive interpretation is given to the various provisions contained in it, the discretion conferred on a court in the matter of striking out a pleading which is not verified by a statement cannot be seen as a speed breaker in the common momentum of the eye.
Which paragraph are you reading?
17.
17.
Well, your lordship said in that paragraph, Milord, your lordship had taken care of Milord order 6 rule 15a. What I am submitting the order 6 rule 15a, order 6 itself is not applying.
Yes.
I mean, ultimately, Milord, who will decide? Milord, it needs a satisfaction of the court.
Yes.
Satisfaction of the court is whether it's a order 21, whether it's a order 15a, whatever it may be, Milord, order 615 rule 15a, whatever it may, satisfaction of the court.
Very well. Is that all, Mr. Bandyopadhyay?
I think so. Milord, another just since my juniors are saying, Milord, this is also Calcutta High Court judgment, Milord, 2009. SCC online 2009 for CHN 125. Paragraph is paragraph 17.
On which point?
That's on the procedural law. Kindly see, Milord, the respective Milord, last few lines of that, just above paragraph 18, it is well settled principle of law. Just above the paragraph 18.
Yes. Yes.
It is well settled principle. Defect of verification of any pleadings is not so fatal at the first instance. But in spite of chance being given, if such defect is not corrected, then obviously such pleadings cannot be allowed to be kept on record. Hence, the defect has been removed as indicated above. Now, Milord, if your lordship ultimately come to, well, let me be very, very honest to your lordship, be very candid after examining everything. Yes, there is a minor defect. That's I agree. What is the defect? Commercial division instead of original site. And it is in the cost item.
So you're saying if you have made all statements which are true, you don't have to file a separate statement of truth. That's
no, I don't need. Statement of truth is not required here. Statement of truth is not required. I need to give a statement under order 21. Read with original side rules. What are the requirements? These are the requirements. What the wrong I have committed? In the court, there in the court, instead of commercial side, I have written original side, so far the statement is concerned. It is not a pleading.
Very well.
It's not covered under order 6 rule 1 itself.
Yes.
Milord,
It all comes down to handmaidens.
Milord, I am remembering, Milord, I just finished with this.
Yes.
It's a very 7 or 8 years practice might be, maybe. I was happy. I was before a bench before the Honorable Chief Justice, Honorable Justice Manojnath Rai and Justice Rumapal division bench. And I was appearing for the Coal India. And Justice M.N. Rai was a highly technical, very technical. Everybody knows about it and knows everything. So naturally taking yes, of course, the judge is very technical. Therefore, I had taken a technical point, very technical point, highly technical point. Justice Rai reacted on me. Remember one thing. Yes, madam. If you want to be a good counsel, never take any technical point, high technical. The court will first react that you don't have any case. Develop legislators.
Thank you, Mr. Bond.
Milord, other points which are on merit that I will.
Mr. Bose, I will hear you on some other day. All right. You can come back with your judgments and please exchange so that we can save time.
Last point কিছু বলিনি তুইও উপরে যে বসলে এরকম হবি
Mr. Bose, when do you want to come back?
Any day convenient, Your Lordship.
Tuesdays or Thursdays? And Thursdays.
ঠিক আছে ও করবে তার মধ্যে আটকে দেবে
When? Give me.
Can we come back on Thursday, my lord?
Thursday.
Great.
Yes.
Before 10th, my lord. 10th.
Before 10th. So
before 10th. Because he has kept his original 34 application on 10th.
Very well. Send then 9th. Yes. Learned counsel appearing for the award holder has made his submissions, essentially response, to the point on Order 6, Rule 15-A of the Code of Civil Procedure, as amended by the Commercial Courts Act, with regard to filing of a statement of truth capitals. Stop. Next, list this matter on 9th January 2024 to hear learned counsel appearing for the award debtor. As prayed for.
Grateful to your lordship. Last 4th January, your lordship was at Jalpaiguri.
Sorry?
Last 4th January 2023, your lordship was at Jalpaiguri. Jalpaiguri bench.
I hope you have some good memories of it, not something.
Of course, every time, Lord, whenever I appear before the lordship's court, always I am having a good memory. Whether I win or whether I lose, that doesn't matter. It is immaterial.
Yes. Thank you.
Your lordship gives a patient hearing, smilingly here. What more I can understand? Want.
Thank you, Ms. Wong. Yes, call on the next matter, please.
I don't know, 48, Board of Jurial.
Petitioner. I appear for the judgment that was made. I was being led by Mr. Shobhushaji Chaudhary. He's on legs.
Sorry,
I
Mr.
was being led by Mr. Shobhushaji Chaudhary. He's on legs, my lord. Your lordship will kindly take this up on Monday.
This is 34.
This is a application for execution of an interim order.
Execution of an interim order, your lordship. The only impediment, if your lordship kindly takes up your lordship's earlier order dated 16th of June 2023, was that there was a Section 37 appeal that had been filed. Now that Section 37 appeal stands disposed of. This is a matter where the deceased partner's son was seeking induction, and in the meantime, the flats have been sold off.
No,
and in
I
driblets
passed a judgment on which point then? Or on which application then?
upheld the Section 17 interim order.
Yes.
The Section 17 interim order was challenged by way of a Section 37.
Yes.
Your lordship has now upheld the interim order. Not only that, your lordship has stated that in the circumstances, it was necessary for securing the amount of 6 crores in the name of the LLP. This is the matter pertaining to the Raghu estates.
Very well. If adjournment, I will keep it on whichever day. When do you want to come back? Monday. No, this has to be a Tuesday or a Thursday.
Tuesday. I'm deeply obliged.
Yes. List this matter on 9th January 2024 as prayed for on behalf of the award. You're the award debtor?
Debtors.
Award debtors.
I'm obliged.
Item number 49, UIC Senbo.
I'm for the award debtor.
Lordship, this is my execution application. This is coming up for a limited point. Lordship, my learned senior had moved an application under Section 36(2) of the Arbitration Act, in which your Lordship was pleased to pass an order dated 19th of June 2023, which your Lordship will find at page 54. Lordship was pleased to direct the award debtor.
54.
Yes, your Lordship, 54 of my application.
Yes. What did that was on your application under?
Lordship, this is on the application by the award debtor, that is my learned friend.
Yes.
for stay of the award. Your Lordship was pleased to direct them to secure an amount of 10 crores.
Yes.
Your Lordship, thereafter, we have no intimation whether this amount has been secured. We have also written letters on 21st of September 2023 asking them whether they have secured the amount and if they could inform us. But Your Lordship, we have not received any reply, and therefore I have filed this execution application. So if my learned friend has secured the amount, Your Lordship, this...
Yes, Mr. Ray, what do you have to say?
It has been secured, I think they should have replied to this letter. It has been secured, on within time,
Within time.
Within time,
That was supposed to be done within 5 weeks.
Yes, Your Lordship.
5 weeks from 19 June.
19th of June.
Down on the 20th of July, seems to be the last date of that 5 weeks.
Whatever, if it's within 5 weeks.
Yes,
fine.
I can hand over a copy.
No, if you're saying it, Mr. Ray, it's fine. Enough. Within 5 weeks done. So what is it now you want, Mr. Kothari?
Your Lordship, if it has already been secured, then Your Lordship, the execution application can go out of the list, Your Lordship, because the award is stayed.
You want to see some document? Then I
No,
can
Your
keep
Lordship,
it.
I can hand over.
Very well. Yes. I can keep it on Tuesday for you to come back with instructions, Mr. Kothari.
Very well, Your Lordship.
Mr. Kothari is very good, Mr. Ray.
I know, Malad.
As a counsel.
As a person also, Malad.
Of course. That is more important.
But anyone from my chamber, Malad, always.
That is why I told you.
The only thing is, Malad, he's vegetarian.
Very well. Tuesday?
Very well, Your Lordship.
Yes. Learned counsel appearing for the award debtor submits that the direction contained in the order dated 19 June 2023 was complied with within time. Stop. Next, however, since learned counsel appearing for the award holder was not aware of the compliance till today, list this matter on 9 January 2024 as prayed for.
On the 11th, Malad, my junior wouldn't be here, Malad, if you're
On the 11th, on 11 January 2024 as prayed for.
Very grateful, Malad.
Grateful, Your Lordship.
Item number 50, IDFC First Bank.
50 is my execution application, my lord. Lordship, there was a direction that your lordship had passed for filing of affidavit of asset. Your Honor. My lord, the judgment debtor number 4 has filed the affidavit of assets, my lord.
Judgment debtor number 4.
But the judgment debtors number 1 to 3 have till date not filed.
Yes, you're appearing for who?
Well, I'm appearing for judgment debtors 1 to 3.
1 to 3.
My lord. May I file? My
And who has filed the assets? Affidavit of assets?
The judgment debtor number 4 has filed, my lord.
Yes,
1 to
what
3 has
about
not.
you?
My lord, I am filing, my lord, affidavit of assets for judgment.
Today in court?
But
Affidavit of assets on whose behalf? All
judgment number 3, my lord.
on 3. What
Judgment
about
number-
1 and 2?
My lord, the thing is that regarding the judgment letter 1, my lord, is I need a bit of more time to get the documents because this company is about in non-operative for about last 2018. It file is returned.
Company? Which company?
My lord,
The number 1.
Number 1, my lord. Last file is returned on 2018. Documents are untraceable. They have shifting of officers. If your lordship may be kind enough for only.
Who also they haven't filed.
No, I have
Who is
collated.
a person?
I have collated the documents, my lord. If your lordship may be kind enough to grant about a week or fortnights of time, my lord, I will do it. I will collate those documents, my lord.
Yes.
If they want to, I won't stand in the way, my lord. They could file it. But the number 2 also, my lord, is a person who appears to be a director of the company, which is judgment debtor number 1. So even for the judgment debtor number 2 also.
Well, I will give them, Mr. Nayak, you were not there on 18
the last
November.
occasion, I was absent. I was
18 November, nobody was here. Not
Right.
only you. No, nobody was here.
I was not.
So I will give them that time.
Yes.
Hi, your lordship will be kind.
Yes. Learned counsel appearing for the judgment debtor award debtor numbers 1-3 seeks time to file the affidavit of assets for the award debtor numbers 1 and 2. Stop. The affidavit of assets of the award debtor number 4 is already on record, and for number 3 and has been filed in court for the award debtor number 3. Stop. Have you filed in court? Yes. Stop. Next, list this matter on. I will keep it on 18th.
Yes.
On 18 January 2024. Stop. The affidavit of assets of the award debtor numbers 1 and 2 shall be filed on the returnable date.
Only one thing, my lord, on the 10th of October, your lordship had directed us to serve on the award debtors number 1 to 3 have served, my lord. This is my affidavit.
The affidavit service is kept on record. Next.
Deeply obliged.
Highly obliged.
Item number 51, MBL Infrastructure Limited.
My lord, I appear for the applicant in this matter. My lord, we've made this application for withdrawal of the security deposited by the award debtor, my lord.
Yes, yes, yes.
On the last occasion, my lord had directed them to find out the value of the cash security that is lying
Yes,
with
yes.
the.
Last order to the
file, I have prepared a supplement, prepared an affidavit.
microphone, please.
I've prepared an affidavit. Lordship, there are certain documents annexed to the affidavit.
No, have you served it on Mr. Mitra and Miss Bormon Ray?
Right now. Lordship, may I file this? Lordship, I had submitted that I shall ascertain what is the status of the fixed deposit in respect to 40 crores, how much is the interest which is accrued. In addition to that, Lordship, there are certain statements made in the petition with respect to a conciliation proceeding which had commenced between the parties. And that conciliation process had reached its finality by way of a recommended settlement which culminated on 3rd of May 2023, Lordship. In spite of the fact that the petition was filed subsequently, the petition is completely silent about the settlement. Now, the recommended settlement had reduced the principal amount. Since the principal amount has reduced, the interest amount has considerably reduced as well. I have annexed the recommended settlement which had culminated between the parties in my affidavit. Lordship will kindly take the affidavit.
What is it, Mr. Mitra?
My lord, there was a post-award conciliation process in-house of theirs. So, my lord, without prejudice, we had participated. Your ladyship will find a reference to that even in our application. But in law, my lord, as your ladyship is aware, conciliation proceedings are confidential. So, we've also said that we are not relying on the modalities of the conciliation. They cannot also rely on it for whatever it's worth. It has failed. Now, the question only is, they have to give the balance cash security for the interest which is accrued in the interregnum. Bank guarantee, they have to replace by way of cash security or have the bank guarantee encashed in my favor, obviously for a counter security. My lord, over here, kindly may I take your ladyship through the orders once. When the execution petition was filed, the outstanding due, including interest, was approximately 82 crore. Now, kindly come to the order of 16 November at page 67.
Yes.
Kindly come to the second paragraph. In light of the above situation, I am of the view that the award debtor must secure the entire awarded amount along with interest. From the calculation provided in the petition, it appears that the amount as on 1st November is 83 so-and-so. Accordingly, I direct as follows. There were two directions. Award debtor is accordingly directed to deposit within 6 weeks a sum of 40 crores as cash deposit with the registrar original side. They have done that. And the balance amount by way of a bank guarantee before the registrar. Then, finally, see B, registrar is directed to put cash deposit in an interest-bearing fixed deposit. Then C, bank guarantee must be renewed each year with an increment of 5% per annum and at least 1 month before the scheduled date of expiry.
Which is due in February.
Now,
Ms.
this
Adlu,
order
you have
was
to wait for your
modified.
turn. Yes.
This order was modified at page 69. Because in the meanwhile, what happened was, they said that, look, according to us, the calculation is not 83, it should be 79. So, having regard to that, kindly see the order. Heard counsel appearing on behalf of the parties. This is an application seeking modification of an order passed by this court on 16 November. According to the counsel appearing on behalf of the applicant, the calculation of the amount payable should be 79 instead of 83 crores. The applicant here was my learned friend, Ms. Addu. The same is disputed by counsel appearing on behalf of the respondent award holder in this matter. To sort out the issue in the calculation, let there be direction for affidavits. Accordingly, let affidavit in opposition, etc. be filed. In the meantime,
No, why affidavits?
because there was a differential of 4 crores. According to me, as per the award calculation, it was 83.
Is to explain.
That's right. So, my lord, we have explained, and in the meantime, the award data, so this amount of bank guarantee, which was 43, was reduced to 39, which they put in. Now, my lord, this.
So how much did they ultimately put in?
40 in cash and the 39.09.
So 79.09.
Yes.
79.09. Yes.
So this cash was invested in an interest-bearing account, and the bank guarantee is lying. Whenever it expires, they will have to renew it. I'm not on that. Now, kindly come to my present application prayers. Kindly come to page, the notice of motion. Why prayer A is the award debtor be directed to furnish additional cash security in the sum of 50. The rationale for this is, as on date, because of the expiry of conciliation, we agreed for a post-award conciliation. So the matter was adjourned sine die by the court. Those orders are there, I'm not placing it. So for 6 long months, we've been trying to settle and thrash it out, could not happen.
6 months from?
I'll tell you.
From this order, from the coordinate bench's order.
No,
16th.
That was the order of 27th March. Kindly have a look at page 86. For the sake of completeness, kindly have a look at page 86.
Yes.
Now, prayer A of notice of motion is at page 76. That was what was allowed.
Yes.
Kindly have a look at page 76, which will give your ladyship prayer A of the notice of motion. This was a joint petition. AP so-and-so, there are 2 34s. I have also filed a 34, they filed a 34, and my execution.
Adjourned for 180 days, which is 6 months.
That's with liberty.
And this was AP filed by?
My lord, 1 AP by me, 1 AP by them. Counter 34s. 2
Yes. Why 6 months adjournment?
Because they had said that they have an in-house conciliation body. If we can go and try and thrash it out instead of bothering the court, it can come.
Yes.
So, my lord, we engaged in that. But nothing came of it. 6 months has long gone in the month of September. In the meantime, my lord, the award, kindly come to straightaway paragraph, page 50, the awarded portion.
Yes.
As per the award, interest has accrued for a further sum of 7.
For the sum of?
7. Kindly come.
7 crores.
Yes, because 83 was when I filed the EC. Now, kindly take page 50. I'll just show your ladyship 2 more pages, and then I'll round up, my lord, my prayer. Page 50 is the awarded portion.
Yes.
In view of above findings, claimant, which is me, is held entitled to a total sum of 56.49 crore with interest at 8% from the date of filing statement of claim till the date of actual payment.
Yes.
Only 8%.
That's right. From the date of filing statement of claim. Now, my lord, simply put, this calculation, your ladyship will have to be troubled by volume 2. The very first page of volume 2. Kindly have that. Kindly have the second last column at page 87. Volume 2.
Yes.
This is my calculation chart. I've given, my lord, a detailed breakup. Claim 1 to 16 is, my lord, really not necessary. Kindly have a look at page 87, second last column, the third last entry, that is total 56 point so and so crore. Then interest from date of filing statement of claim, i.e. 2011-2017 to 13-12-2023, 34 crore at 8%, but from 70. Bringing it, my lord, to 90.56 lakhs. So, my lord, the situation today is this. They have 40 crores in cash deposit, 39 by way of bank guarantee.
Yes.
According to us, it has become 90 crore in total. So, we don't want a bank guarantee anymore. They should give the cash security for the additional 50 and they can take back their guarantee. And we should be permitted to withdraw that on a counter security. And my alternate prayers are framed otherwise. Because, my lord, this fact, I sincerely hope that this will not be in dispute. What we discovered in the conciliation process is that they had to actually furnish the guarantee with 100% margin. In other words, they are out of pocket by the same amount. Usually, my lord, the advantage that a litigant gets out of bank guarantee is they deposit, let's say, my lord, 20% with the bank as margin. And they give a guarantee for 100 rupees with only 20 rupee out. But from what we've gathered, they had to pay the full amount. So they are really not prejudiced either way, whether it's guarantee or cash, they are out of pocket. And my lord, now, my lord, your ladyship has also held in BBM. There are other judgments, Lakshmipat Surana, and there are other judgments of the Supreme Court also, in the context of arbitration 36s and summary suit 41.5s, saying that the entire amount should be really secured. And kindly have a note once more of the page number 67. The learned judge, when first passing the order for security in this matter, observed that the entire amount should be secured. And the entire amount at that time was 83.
Yes, which they later changed to 79 something.
Changed till it was finally decided. But the rationale of the learned judge was you should secure the entire. Now, this passage of time, this conciliation, they can't enjoy the fruits of a stay. And kindly see, the amount is not small. It's not increased by 7 crores. It's 8% on a principal sum of 56 crores. And I am a company which has recently come out of the CIRP process.
So you're claiming the additional, you're saying now the interest is 7 crores additional.
Additional, that's right.
And but what is the additional amount you're claiming? 50?
50, if 40 crores already given in cash.
Yes.
So, my lord, now if the amount is 90, they have to give the balance 15 cash. But out of this balance 50, 39 is covered by a bank guarantee at present. But kindly now see alternative prayer B, which I framed. Because, my lord, there are two scenarios. Either they give the entire 90 crores in cash.
Yes.
In which case they can take back their guarantee.
Out of which 79 is already given.
No.
Out of which 40 is given
That's
in
right.
cash.
So that 39 bank guarantee, I will not be bothered with anymore. If they agree to, or if there's a direction to give full cash, they can take back their guarantee, no difficulty. And the alternative is prayer B.
Yes.
Alternatively, the award debtor be directed to furnish cash security for 1146. 1146 is nothing but the present due 90 minus 79, which was already secured. So they should give that balance in cash, and the bank guarantee for 39 crore be encashed, deposited with register, and I'll take them. It comes to the same thing. It comes to the same thing. They are out of pocket.
So A and B comes to the same thing. That's what you're saying.
Conclusion is the same, different routes. I get the money on a counter security or any other term as your ladyship may deem appropriate. Either there can be a direct cash security by them, which will avoid any complication.
Yes.
Give 50 crore cash, take back your guarantee, I'll withdraw. Or you give the balance 11 crore in cash and let me have the fruits of that 39 crore bank. And my lord, to demonstrate why I'm asking for this, not only was this conciliation at the, for 6 months, but my lord, I am a company which was under CIRP. I'm an infrastructure company. My lord, the Supreme Court, when our matter went up to the Supreme Court, kindly have a look, my lord, at page 127. The Supreme Court's order upholding the resolution plan starts at 88. But what is important are the two findings, my lord, at paragraph, at page, my lord, 127, page para 63. This was what the Supreme Court held. Just to show, my lord, that we are not a fly-by-night operator. Kindly see para 63. This is what the Supreme Court held in our NCLT matter. Yes. We need to take note of the interest of over 23,000 shareholders and thousands of employees of R1. Now about 300 crores has also been approved by shareholders to be raised by R1. It is stated that about 63 crores has been infused to make it functional. There are many ongoing projects of public importance undertaken by R1 in the nature of construction activities, which are at different stages.
R1, and who was the petitioner?
My lord, the petitioner was a bank, Bank of Baroda.
Very well.
So, my lord, in these circumstances, when the learned judge has said entire amount, that differential should be put in, and I should be given, my lord, the benefit of that amount. Otherwise, my lord, and I'm willing to put in, my lord, whatever safeguards there are to be put in place. And that's the calculation.
Safeguards by way of bank guarantee.
Yes, my lord. Whatever. And yes, I have quickly perused, my lord, the supplementary handed over today. My lord,
Mr. Mitro, I won't have time to dictate the order today. So what you do is, whatever you have said, Just in one page,
Very well.
just to make it clear.
Very well.
The A and B alternative.
Very well.
I more or less remember, but
I'll do
whatever
so.
it is.
I'll do so.
And what are you saying? What should be done to go through the affidavit for what?
I'm led by Mr. Dutt.
Yes, yes.
The affidavit contains, my lord, the calculation which we got from the register yesterday as per your lordship direction.
As to the additional the interest part, how
Not
much
just
interest
the
it has
interest part, But my
earned?
lord, the additional amount that, my lord, according to them, which I have to put in. And my lord, also I
No,
have
no. How is it different from what Mr. Mitra is saying?
the calculation of interest is perhaps not correct.
Sorry,
The calculation of interest is perhaps not correct.
not connected.
Not correct.
Not correct.
Not correct. Because there was
Mr. Mitra, why don't you do this? It's such a small matter.
I'll sit with Mr. Dutt.
Yes. Just calculate all this and
Very well.
then just come up. I will pass the order.
And reconcile it amongst ourselves. At least the figures,
Yes.
your ladyship should
Yes.
not be troubled by controversy on figures. We'll sit and try and see what the point of difference is. Lord, if we can come back anytime, Lord, next
Tuesday.
week. Lord, Tuesday, I'm in some difficulty. Could it be, Lord, Wednesday instead?
You don't know it's a chamber matter.
Could it then be Thursday, Lord? Tuesday, I'm not in Kolkata. That's the only reason.
Yes. Learned counsel appearing for the petitioner / award holder has explained, has placed the relevant figures on which prayers A and B of the application are based. Stop. Next, however, comma, no, learned counsel opinion for the award debtor seeks to rely on an affidavit to show that the computation of interest, comma, as given by the award holder, comma, is not correct. Stop. Next, the disparities, the discrepancies in the figures should be sorted out by counsel appearing for the parties. Stop. Next, there is there is the court would have liked to pass the order today, but there is no time for that. Stop. Next, the next list is matter on, when do you say, 11th? 11 January 2024, as prayed for.
I'm great.
And just so that, I can just look at that piece of paper and start dictating.
I've understood.
Non-commercial matter, item number 1, Sri versus Anandi Kumar Maji.
Lord, I am for the petitioner. This matter has come up at my instance, Lord. Your Lordship was pleased to direct the registrar to file a report.
Yes, so no, the report is not filed as yet.
Report come to your
And what about, what are these two amendments?
Lord, first amendment.
Microphone, please.
The first amendment took place due to the death of the respondent.
Yes.
Lord, I did the necessary amendments pursuant to Lordship's order. While carrying out the amendment, it was found that one paragraph in the petition is missing. For that, the second amendment was brought in. But that also your Lordship was pleased to allow upon payment of cost. The cost has also been paid. Now the department has raised the question that the second amendment can be done in time.
1 minute.
Yes.
Very well. I will direct the report to be circulated so that you're for all the respondents. Respond one. The report of the learned registrar, original side dated 4th January 2024, which has been prepared, which has been prepared pursuant to the direction passed by this court on 19 December 2023, should be circulated among the parties. Stop. Next. The advocate on record of the petitioner will make copies of the report and circulate it and circulate it to the respondent before the returnable date, which is fixed on.
As your Lordship. Next week.
8th January 2024.
Item number 2, Shubhankar Chakraborty.
I am for the respondent.
Who is for the petitioner? Nobody appeared or what? কি হয়েছে? Yes, yes. ডিটটা কি কোর্টে পাঠিয়ে দিয়েছে? Yes, the matter has been brought to the list at the instance of the court. Stop. Next, the registrar's report dated 2nd January 20, the report of the learned registrar, original side dated 2nd January 2024. Indicates that the title deeds deposited by the award debtor within brackets petitioner in AP 291 of 2023 close brackets of the land in question, which was directed to be deposited with the registrar, was subsequently sent to the court. Stop. Next. It is not clear as to why the learned registrar would send the title deeds to the court instead of keeping it with herself for safekeeping. Instead of keeping the deeds with herself. Stop. The direction was for depositing of the title deeds with the registrar. Stop. Next. Title deeds holo kothay? Yes. The title deeds, the registrar shall hence keep the title deeds with her for safekeeping until further orders. Until the court passes further orders on the application. On the application, further orders, stop.
Item number 3, aluminum cables, 3 and 4.
Your Lordship, we were supposed to file an affidavit, supplementary affidavit by way of an order dated 12th December. By 20th of December, we have filed, we have got it ready. We were out of time one day after the holidays. So
supplementary affidavit for what?
A supplementary affidavit because this was an addition of parties application. So we wanted to put in documents to show that I am the son of the contributory, which perhaps were missed out inadvertently. So those documents have been placed. We have given a copy to my learned friends also.
And what turns on it? If you're not the son, then what happens?
Your Lordship, then I cannot be added as a party. That is the problem. Your Lordship, this is the supplementary affidavit.
Yes. What about, what is it, Mr. Shahu? Sorry, yes.
I am for West Bengal State Electricity Distribution Company.
Microphone, please. Yes.
I am for distribution company.
Mr. Shorkar, yes.
I am. They have.
No, what is this application for, Mr. Sinha?
Yes, Your Lordship, what has happened here is the company went into liquidation in 1989. I am the representative of the majority shareholder and the erstwhile managing director and director of the company. So I am a contributory of the company. What has happened here is in 1983, when this suit was filed, an amount of around 12 lakh rupees was placed in with the original right registrar, with the two joint receivers. With two joint receivers, which money is now a considerable sum, which has
pursuant to orders of court.
Orders of court.
Yes.
Orders of court. Now, West Bengal State Electricity Board,
yes,
as it was then at that point of time.
Whoever's mobile is it? It is. Please hand up or leave the court. Yes.
Your Lordship.
Yes.
Now, what has happened is that money is still lying with the joint receivers. That is a considerable amount of sum.
Yes.
The official liquidator thereafter has paid off all the workers and everybody has been paid. There's nobody else is left. So the contributory, otherwise, if the money is, whatever money is remaining, the contributory is entitled to it. Now, the West Bengal State Electricity Board, thereafter, what has happened is, has been bifurcated into two different companies.
Yes.
My learned friend represents one of them, and there is another company which is also there. No documents have been shown to whose account, even if any, to whose account that receivable has been passed into. When the company bifurcates, the different balance sheets will show to whose account one receivable has been transferred. That document has never been shown. That has to be tested. What their contention is that now that nothing has been paid, it was because it was against them, they should be paid.
So
the
you
entire
want to
money.
be added as a party?
Yes, that is all that. At this point, I am only seeking that.
Yes, Mr.
In this
Shorkar.
Yes, my lord. After winding up of the plaintiff, it is the statutory authority that the official liquidator will represent the interest of the creditors and contributors.
Yes.
They are there. They are representing parallelly.
How are you prejudiced if I add him as a party?
My lord, my submission is, my lord, for the one litigant, how two persons will be represented, I do
No,
not.
but that one litigant has died.
That litigant has died.
Then?
My lord, official liquidator is representing the representing for the creditors and contributors.
Yes.
And they are looking after their interest. Now, in spite of the appointment of official liquidator.
So you get some money from the company.
Yes, my lord, that is our money. Our money that has been bank guarantee has been invoked, and that is being deposited at fixed deposit before the bank
and that is aluminium cables, which has gone into liquidation.
Yes, liquidation.
Yes, and what's the stand of the official liquidator?
Lordship, regarding the addition of party, your lordship, this subject matter of the suit, your lordship, is.
I can't hear you. Microphone.
Lordship, the subject matter of the present suit relates to the injunction that the bank guarantee, the term of the bank guarantee is not extended, as well as the bank guarantee should not be invoked at any point of time. That's the subject matter of the suit. Now, in this particular matter, Your Lordship, my learned friend, which is coming up with the addition of party, Your Lordship, this application may not be entertainable, is not maintainable, perhaps because, Your Lordship, the party who is seeking to be added here is not a proper and necessary party in this particular matter, depending on the subject matter in question, which is in dispute, Your Lordship. So regarding the contributories and other things, Your Lordship, they can place separate
What is the
applications.
subject matter? That the bank guarantee should not be invoked?
Lordship. Because and there was a term, 18 months term, and the bank guarantee was in charge of the joint receivers. So now at the point of time, we have to understand and ascertain whether the bank guarantee has been renewed or not. That the joint receiver can come up and answer well. Now the point at this juncture is that whether the question which is required to be adjudicated in this particular issue is that whether my learned friend's application, regarding my learned friend's application, is that whether the party concerned is a proper or necessary party.
Yes. Why is it improper and unnecessary?
Because, Your Lordship, in this, the subject matter which has been disputed here, Your Lordship, does not relate to any claim to the relates to any claim to my learned friend's client. That is the situation, Your Lordship.
Can't understand. Are you ready with the matter or are you not?
Yes, because, Your Lordship, what my learned friend is stating is that he is also one of the contributory. But regarding this bank guarantee issue, Your Lordship, he can come up with a separate application, Your Lordship. Seeking any, and apart from this, Your Lordship, we have to
Yes, you don't sound very ready. Yes, what do you have to say?
Milord, bank guarantee, my learned friend has submitted that the bank guarantee should not be revoked. That was their case. But bank guarantee has already been revoked. And the
yes, Mr. Sinha.
Yes. Your Lordship, may I just submit this? This is with regard to a company in 1983, which there was a direction which was passed that not to the bank guarantee cannot be encashed.
On your suit?
On my suit. The company's suit. Company in liquidation. The company has got into liquidation in 1989.
Yes.
The money which has been lying with the joint receivers is now payable to the contributories. So I have a direct link with regard to that money. That money which will be paid to me. Now, if the money is now not,
and what is the assumption that the money should go back to the contributories?
Your Lordship, that is the law with regard to if there is no.
Yes, but you're not the only contributory.
Your Lordship, I represent the majority of the contributories. I represent the majority because I have my father was the majority shareholder of this company.
So yes, but the money cannot go entirely back to you.
No, I'm not back to me at all. I'm not saying that the entire money goes to me.
Yes.
I'm saying the official liquidator is there. They will make the distinction, but I am there to protect my interest. I'm not saying that I'm a necessary party. I'm a proper party, and I want to be added because I want to protect my interest. Only to that extent. And to that extent, Your Lordship, in this matter, which is a checkered history, I have been allowed, in spite of the fact that this application had not been considered for years, but I have been allowed to argue. We have argued on my arguments. Matters have been decided in the division bench. This point, the official liquidator is taking today, has never been taken up before any of the courts. Today, it's a new submission that I cannot, because I am not a proper party or a necessary party.
No, what was the stand of the official liquidator then before the other
No,
courts?
no stand at all against any of the interveners. See, both the interveners are here. One has been added, and another person.
Who's the other one?
The defendant here, he's an added party.
Yes.
He is not defendant number one.
WBSCDCL.
Yes, he's an added party.
Yes.
The defendant number one does not exist anymore. The defendant number one today does not exist anymore.
WBSCDCL.
West Bengal State Electricity Board is the defendant number one, Your Lordship. That does not exist. That company has bifurcated into two companies.
Yes.
So they also made an application. They were interveners. We were interveners. Both of us have been heard extensively. And the official liquidator, Your Lordship, I can get all the orders, has never come up and objected to any of us representing in the court. Because if the official liquidator has to take it up, he can take it up.
Mr. Sinha, have you got the orders or should I keep it for tomorrow or whenever?
Which all the orders where we have appeared?
Not tomorrow, Monday.
Monday, Your Lordship keeps a Monday. I will show all the orders where I have appeared.
Yes.
And not taken any.
Not where you have appeared. All the orders which help you, which assist your case.
Very well. Yes.
For being added as a party.
Very well, Your Lordship. I'll.
Yes.
Lordship, the matter can be fixed on Tuesday if you Lordship.
Why? Why not on Monday?
Lordship, Monday, I've got some personal difficulty. My Lord, please, I'll come.
Very well, Your Lordship. I don't do Tuesdays.
Very well. the applicant, comma, who is the son, who are you?
Son, your lordship.
Who is the son of a major shareholder of the company in liquidation and a contributory thereof, comma, seeks to be added as a party to the suit. Stop. The suit was filed by the company in liquidation against the defendant number one for restraining the defendant number one from invoking a bank guarantee given by the company in liquidation. Stop. Next, learned counsel appearing for the applicant seeks to rely on a series of orders where both the applicant as well as the who is Mr. Sharkar representing? As well as WBSCDCL were heard in their respective cases for intervention. Stop. You have already been added as a party. Yes. WBSCDCL was subsequently added as a party on.
I think she's ordered, I think.
Give me the year at least. Subsequently added as a party by a coordinate bench. Stop. Next, list this matter on 9th January 2024 as prayed for on behalf of the official liquidator.
Your lordship, the order is 8th May 2017.
Was subsequently added as a party on by a coordinate bench on 8th May 2017. The supplementary affidavit on behalf of the applicant is taken on record. Is taken on record. Next.
Item number 5, Infra.
My lord, item number 5 is my petition under section 29A subsection 4 of the Arbitration and Conciliation Act. I am seeking extension of time, my lord, to make and publish the award. My lord, in this...
You are the arbitrator?
No, my lord, I am the petitioner.
Then why are you saying to make and publish the award?
Extension of time for the arbitrator to make and publish the award, my lord.
Yes. First extension?
Yes, my lord.
Who is the respondent? When did you serve them?
We have served them, my lord.
When?
And my lord had allowed us to file a supplementary affidavit on the last date. We have to bring on record all the minutes of the arbitration.
When did you serve them?
My lord, we have served them by email, my lord. I'll just tell my lord.
By mail? When? They are in Gurugram.
Yes, ma'am. Service for them. My lord, we have served them, but
Learned counsel appearing for the petitioner will get the requisite documents with regard to service. Stop. Next, list this matter on
any date convenient to my lord.
But you have to be ready. You can't come and look
My
for
lord,
documents.
I apologize. But in service
On 8th January 2024. The supplementary affidavit of the petitioner is taken on record.
Item number 6, Rohit Kumar Kothari.
This is my application under section 11, my lord, that I had already placed. This is my application under section 11, my lord. I had already concluded my submissions, and my lord, it was kept for the respondent to reply to my
Yes,
submissions.
what is the point, Mr. Sen?
Your lordship,
Microphone, please.
the invocation notice has been issued. It is at page 60 of the petition, while it has been issued only in respect of a purchase order dated 31st March 2018. Your Lordship, that particular purchase order is at page 21. 21 of the petition, Your Lordship. My point is that if the arbitration clause has been invoked only in respect of this particular purchase order, then disputes arising out of
Show me the section 21 notice.
Yes,
Don't
Your
you think
Lordship.
it's
Section
important for
21
you?
notice is at page 60. Page 60, the Roman 2 paragraph, that the noticee number 1, Simplex Infrastructure Limited, is a well-established private construction company that engaging in infrastructure development project, you, the noticee, placed a purchase order bearing number as dated 31/3/2018 for purchase of admixture, make BASF and so it is clearly the notice of invocation is in respect of this particular purchase order. And it is not the case that the purchase orders, the other purchase orders which have been relied upon in the petition is for the same work. Well, it is for two different works.
How do you know that?
Yes, Your Lordship. Well, it kindly takes the first one, my lord, page number 13, annexure A. This is a purchase order dated 18th December 2017.
Yes.
Well, this is for contract number 2867. Jammu and Kashmir Express Highway construction contract. Well, then, kindly comes to page 17. This is another purchase order of 21st March 2018. This is in relation to a project site at Ramagundam, Fertilizer Complex, Telangana. Well, the invoices or the amounts that have been claimed in the instant application or other for which my learned friends wants to go to arbitration.
So you're saying 13 is for Kashmir, Jammu and Kashmir?
Yes, Your Lordship.
And 17 is for Telangana?
Yes, Your Lordship. Different work sites. And then, my lord, again, the purchase order in respect of which the arbitration agreement or the arbitration clause has been invoked is at page 21. This is again for Srinagar, the construction of flyover project. But my lord, what my learned friend has essentially sought to invoke is the purchase order dated 31st March 2018 in their invocation notice, and kindly comes to page 10 of the section 11 application, my lord. They refer to two purchase orders. That is the purchase order dated 31st March 2018, which is in respect of the construction of flyover at Srinagar.
Where is the arbitration clause?
Yes, the arbitration clause, my lord, is at page 26. Clause number 23 it is. Well, this is in respect of what they have invoked. In the event of any difference or dispute arising out of or in connection with this order, the same should be first amicably settled by mutual dialogue, not complied. There is no notice of any mutual settlement. That's another point, Your Lordship. If the parties fail to settle the difference or disputes arising out of or in connection with the order, including interpretation of the terms thereof, the same shall be referred to arbitration. The arbitration proceeding shall be conducted by a sole arbitrator, while the venue is at Kolkata, and there are the other
And the arbitration clause in the other purchase order is identical?
Yes, Your Lordship, it is identical.
And what about the third purchase order at 27?
Yes, Your Lordship. The third purchase order at 27, the arbitration clause is at page 31.
So this is also for Jammu and Kashmir?
Yes. This is also for Jammu and Kashmir. At page 27. Well,
Same as 13.
Same as 13. However, the project site is one of Telangana and one is of Kashmir Srinagar. Then the invocation notice is again only in respect of one purchase order, and there is the other point, the claims are also barred by limitation as on the date of invocation. Your Lordship, the payment terms is there, my lord, at page 24. If Your Lordship takes page 24, 30 days credit. They admit that the payment had to be made within 30 days from the raising of the invoice.
So 1, 2, and 3 are the same for Jammu and Kashmir. What about 17 is which one?
17 is, your lordship, for Ramagundam, Telangana.
Okay, so 1, 21 and 27 are the same.
Yes, your lordship.
Yes.
21, 27 are the same.
Yes. So there's only one purchase order which is for Telangana.
Yes, your lordship. And in respect of which they claim in this application. They claim in respect of Telangana as well as that Srinagar project, your lordship.
No, the invocation notice you said
Invocation is
mentioned-
notice in respect of only one purchase order.
That's Srinagar.
That's Srinagar. But
Very
in this application, they have referred to two. That's of
Yes.
Telangana as well as Srinagar.
Very
And-
well. Yes, Mr. Das.
My lord, there are 4 purchase orders. My lord, after the application was filed, on the very first occasion when the matter was moved, I had indicated that with regard to the Telangana project, I am not making any claim. My lord, I have indicated at paragraph 8, continuation of paragraph 8, page 5, there are several invoices in respect of which there were outstanding dues for which I had made the claim. My lord, the first 2 invoices pertain to Telangana and I am not making that claim. My lord, that can go on record. I shall be only making claims in respect of the unpaid invoices from 3 till 8, which is at page 8, paragraph 8, page 5, my lord. Well, in my notes of argument also I've indicated that.
Yes. So you have you are making only
First two bills and invoices, I'm not raising any claims. These are invoices appearing at pages
no.
30.
So which one are you making a claim for?
My lord, from 19th April, the invoice dated 19th April, CPL 153,
Yes.
318,
Yes.
617, 1117.
So till the end.
Till the end, man. All these invoices pertain to the Jammu and Kashmir project.
Very well. And
My lord,
what is the claim?
my lord, the claim amount would come up to approximately 31 lakhs on principal, and thereafter have claimed interest thereon.
How much is the claim?
30 lakhs, 96,000 odd, my lord. My lord, this amount is indicated in paragraph 11, my lord. My lord,
And your 21 mentions only one.
it mentions only one, my lord. It mentions the project at Jammu and Kashmir. And my lord, there were 3 purchase orders. To place candidly, my lord, there were 3 purchase orders. Only one of them is referred, but all these purchase orders pertain to the
So
same project.
how many relate to the Jammu and Kashmir project?
My lord, three out of the 4, 3 relate to the Jammu and Kashmir project. I am making claim in respect of those 3. Well, the only error that was there in the 21 notice is that it refers to only 1 out of the 3.
The dispute.
Your lordship, there is also one more point. My lord, even if that is the case, that they are giving up the claims in respect of the first 2 bills, my lord, in paragraph 11, they admit that they have received 40 lakhs. My lord,
Let the arbitrator decide.
yes, your lord.
Yes. The dispute between the parties relates to unpaid invoices of the petitioner with reference to the work performed by the petitioner in respect of 3 purchase orders issued by the respondent in from 18 December 2017 to 24th September 2018. Stop. The petitioner was to construct flyover / expressway corridor between 2 places at Srinagar, Jammu and Kashmir. For the Jammu Kashmir Economic Reconstruction Agency. Stop. The claims, the petitioner's claims have been tabulated in paragraph 8 of the petition and numbers and are 6 in number. Stop. The claims are particularized in respect of the claims are given in respect of particular invoice numbers. Stop. The petitioner was unable to convince the respondent to make payment for the work done by the petitioner in respect of the 3 purchase orders, and was ultimately constrained to invoke the arbitration clauses in the 3 purchase orders on
July 20.
11 July.
11
is the
July
letter.
2020.
11th July 2022, referring, however, only to 1 purchase order. Stop. The respondent did not reply to this notice. Stop. Next, learned counsel appearing for the respondent argues that the purchase orders are unrelated insofar as one of the 4 purchase orders, one of the total of 4 purchase orders relates to construction work in Telangana. Telangana, Telangana. Stop. Counsel also submits that the Section 21 notice mentions only 1 purchase order instead of 3. Stop. Next, after considering after considering the submissions made on behalf of the parties, there is little doubt that all the 3 purchase orders placed before the court relate to construction works for the same highway in Srinagar. Stop. The petitioner, learned counsel appearing for the petitioner, gives up the purchase order, the claim in relation to the purchase order of the construction work done in Telangana. Stop. Next, whether the invocation notice, whether the notice of invocation mentions 1 or 3 purchase orders is of little relevance, where the respondent admittedly is in default of its statutory obligations with regard to payment to the petitioner for the work done in Srinagar. In respect of the construction works in Srinagar. Stop. The decisions given by the Supreme Court as well as the High Courts provide for a consolidated reference, and this court sees no reason for dismissing, for disallowing the application on technical grounds. Stop. Next, the petitioner's claim amounts to approximately rupees 30.96 lakhs, 30.96 lakhs on account of unpaid dues. Stop. The disputes between the parties are directly relatable to the arbitration clauses contained in the purchase orders, in the 3 purchase orders. Stop. Next, AP 844 of 2022 is accordingly allowed and disposed of by appointing blank. Paragraph to be communicated by 6 January 2024.
At the point of limitation, we also kept open, my lord. Because
Naturally.
apparently, my lord, if that line can be there, because
Why?
your lordship, the order has gone like there is a default on part
Yes,
of the respondent. That's the reason.
point of limitation will be kept open for being decided in the arbitration.
My lord will kindly grant me liberty to invoke any second reference, any separate reference with regard to the Telangana project. Lord, since I have not issued that in this letter, I would be invoking, my lord, that may kindly grant me
Yes,
that.
liberty to the petitioner to invoke the arbitration clause in respect of the remaining purchase orders. Next.
Item number 7, Messrs. Siemens Healthcare Private Limited.
Can't hear you.
Lordship, I beg to appear on behalf of the petitioner, Lordship. Lordship, today is the first time it is appearing, Lordship. I have served, but till date it has not been reached, Lordship. I have served.
Where are they? Where is the respondent based?
Lordship, respondent,
Odisha.
Lordship, Cuttack.
How much time do you want?
Next week, Lordship, any day, Lordship.
Yes, learned counsel at the council. Learned counsel appearing for the petitioner seeks time to complete service on the respondents. Stop. List this matter. Next. List this matter on 10th. When do you want it? 10th, 11th?
Lordship, 10th.
10th January 2024.
Correct.
As per. Next.
Item number 8, Tata Capital.
Lordship, I'm appearing for the petitioner in this matter. Lordship, this is my Section 9 application. I've served to the respondent. Lordship, this is my affidavit of service.
When did you serve them?
Lordship, I have served them on 7 December 2023. Lordship, respondent number 1 has received on 11 December 23, but articles is yet to be delivered to respondent number 2, Lordship.
Next, they are in Birbhum.
Yes, Lordship.
Birbhum. So when do you want to come back?
Lordship, if you permit, I'll serve again to the respondent number 2 and then come back after 2 weeks.
Yes, list this matter after 2 weeks as prayed for. Stop. Service to be effected on the respondents once again.
Great, Lordship.
Next.
Review application. Item number 9, what is Infra Energy.
So this is my review application, Your Lordship.
Of what?
Lordship, an order passed, Your Lordship, in an application under Section 36 of the Arbitration and Conciliation Act. The short point, Your Lordship, is involved that when Your Lordship, Mr. Sain, Your Lordship, the petitioner in.
No, where is the order?
Lordship, the order.
I'm looking at the memo.
Yes,
yes you have annexed it. Yes.
Lordship, 5th March 2021 order. If Your Lordship kindly take.
Yes.
Internal page 4.
Yes.
Internal page 4, Your Lordship, last paragraph. Upon considering the documents which have been shown to the court, GA 2 of 2020 is allowed in terms of prairie. There shall be stay of the impugned award dated 31st January 2020 upon the applicant putting the amount of rupees 1,30,51,678 in an interest-bearing fixed deposit and furnish the details of the same to the registrar original side of this court and the court shall monitor the same. The amount shall be put within a fortnight from date. It is understood that till the amount is put in, there shall be no further steps taken in respect of the impugned award against the applicant. If the applicant fails to put in the amount as directed, the order of stay shall automatically be vacated. My Lordship, kindly take once, Your Lordship, the arbitral award.
No, what is the ground for review? Order 47
The ground for review, Your Lordship, is when, Your Lordship, this particular application for stay was moved. At that point of time, Your Lordship, the higher consulting judgment was there.
Now, in the arbitral award, your lordship, there, apart from this particular principle,
Hyder Consulting has gone.
no, at that point of time was there, but your lordship, it was not produced before the honorable court and for your lordship's consideration. Now, your lordship has only secured the money in connection with the principal sum and not your lordship the interest amount.
You're the award holder.
I'm the award holder. Now the thing is, your lordship, immediately your lordship, after your lordship this judgment and subsequent judgments your lordship came, then your lordship will file this application for review.
Hyder Consulting is of 2021.
Before that, before your lordship before this particular order your lordship was passed.
Yes.
If it is subsequent, your lordship, I can consider your lordship can think of your lordship that it could not be produced. It was mistake on our part. That the relevant law at that point of time, your lordship was not placed before the honorable
So you
court.
want the post award or the pendant elite? Which one do you want?
Both, your lordship. Regarding the pre-award interest, your lordship, the arbitral tribunal, your lordship has given me.
Yes.
14% interest.
Yes.
And your lordship, the post-award interest, your lordship, the honorable tribunal has not provided me. Still, your lordship, as per section 31 of the subsection 7B of the Arbitration and Conciliation Act, your lordship has powers, your lordship, to secure in connection with your lordship the post-award interest. That is silent. I'll show your lordship the Honorable Supreme Court's judgment. Your lordship, kindly take once your lordship the arbitral award.
So what is it that you want now? Post award interest?
Pre-award and post-award both. Because this 1 crore 30 lakhs, your lordship, is the principal amount only. Lordship, kindly take page 86 once. That's the arbitral award. '86, your lordship, the award starts, and your lordship, kindly take page 107, which is your lordship, the operative portion of the arbitral award.
Yes.
Page 107, paragraph 22. Under the circumstances, in my view, the claimant would be entitled to recover from the respondent the amount of invoices to bills mentioned in the said chart, being Exhibit J, aggregating to rupees 1 crore 30 lakhs 51,678. So this is the principal amount. The claimant, however, would be entitled to interest on such principal amount from 28 February 2013 at the rate of 14% per annum, was claimed by the claimants in his legal notice, being Exhibit I in this proceedings.
What is 28th February?
Lordship, 28th February, your lordship, is the date, your lordship, from when your lordship the particular amount was due, accrued, your lordship. That's why, your lordship, the honorable tribunal has given me, your lordship, interest from 28th February 2013.
Yes.
Because that's the, your lordship, the letter of confirmation where, your lordship, they have admitted regarding, your lordship, 1 crore 30 lakhs 51,678.
So this is their letter of admission.
Their letter of admission.
Yes.
And now paragraph 23. Accordingly, there would be an award in favor of the claimant and against the respondent for a sum of 1 crore 30 lakhs 51,678, along with interest at the rate of 14% per annum from 28th February 2013 till the date of the award.
So you were given pendant elite.
I have given pre-award interest, not regarding the post-award interest.
Till the date of the award.
Award. And your lordship, I am entitled for pre as well as post both, because pre-award interest has also not been secured.
No, interest is under at least 31(7).
31(7).
In 3 brackets.
Yes, your lordship.
Pre-reference, pendant elite, post-award.
Post-award.
That's 31(7).
Yes, your lordship.
So which is one you want?
I want, your lordship, as per the arbitral award, yes, your lordship, I am entitled for the pre-award interest.
Yes.
14%. And it's your lordship discretion after post-award. I'll show your lordship that judgment of Morgan Securities versus Videocom, where the Honorable Supreme Court has said, your lordship, if it is not mentioned, then also, your lordship, the Honorable Court has powers, your lordship, secure that post-award interest. Today, this only 1 crore 30 lakh has been secured. Not only, your lordship, the pre-award interest has been secured.
Yes. So pre-award means what? Pre-reference plus pendant elite.
Yes, your lordship.
But then this interest is on which account then? 14%?
14% on this particular amount, 1 crore 30 lakh 51,678. That is, your lordship, during the pendant.
So this is pre-award and pendant elite. That means. So you are only entitled to post-award. That means.
I am entitled for post-award also, but this particular pre-award interest has also not been secured, because 1 crore 30 lakhs, your lordship, is the principal amount.
Very well. So 1 crore 30 lakhs is this 14%, which has been given.
No, 1 crore 30 lakhs, your lordship, is the principal amount. And 14% interest, your lordship, I
No,
have
no.
calculated.
So 14% interest comes to how much?
Yes, your lordship. Lordship, kindly take page 8 of my application. I have calculated it. Page 8.
Yes.
Page 8, your lordship, paragraph 14, as on date, the interest component as awarded by the arbitral tribunal and by virtue of section 31, subsection 7, subclause B of the Act of 1996, an amount of 1,84,18,000 is due and payable by the original petitioner to the applicant and details thereof. So I have calculated interest at the rate of 14% from the principal amount on and from 28th of February 2013 till 31st January 2020. Lordship, that is coming to 1,38,375.
No, what is this? Where have you getting this 18 July 2022 from? 18 July?
28th February 2023.
Next page, Mr. Shengupto.
18 July regarding the date of the filing of the application.
Yes. And what does Hyder Consulting say?
Hyder Consultancy, your lordship.
Hyder Consulting was post award. I thought Hyder Consulting was before 2021.
Lordship, it was passed, your lordship, on 2015 to SCC 189.
Yes.
Lordship, kindly take, your lordship, paragraph 28. Para 26 and 27, your lordship, that was an interpretation of 31(7)(a). 28, your lordship, therefore, for the purpose of an award, there is no distinction between a sum with interest and a sum without interest. Once the sum and the interest component cannot be segregated and be seen independent of each other, the interest component then loses its character of an interest and takes the color of sum for which the award is made. There may arise a situation where the arbitral tribunal may not award any amount towards principal claim, but award only interest. This award of interest would itself then become the sum for which an award is made under section 31(7)(a) of the Act. Thus, in the pre-award stage, the legislation seeks to make no distinction between the sum awarded and the interest component in it. Therefore, I am inclined to hold that the amount awarded under 31(7)(a) of the Act, whether with interest or without interest, constitute a sum for which the award is made. So my humble submission is 1 crore.
That's fine. But Hyder Consulting, that's some part I remember. But that was with regard to pre-award or pending deleted?
Lordship, is pre-award.
Pre-award.
Pre-award. And your lordship, regarding the post-award, this is reported, your lordship, in 2023, 1 SCC 602. So Morgan Securities versus Videocon Industries. Lordship, kindly take, your lordship, page 609, paragraph 12.1. 12.1, section 31 subsection 7 does not make any reference to the payment of compound interest or interest on interest. The phrase sum directed to be paid by the award refers to the award of some or substantial claim, that is the principal amount. In absence of a provisions enabling the grant of compound interest, such a power cannot be read into the provisions either for the pre-award period or for the post-award period. A high rate of interest at 18% is statutorily recognized in section 31(7)(b) for the post-award period to deter the award debtor from delaying the payment for monies as directed in the award. Section 31(7)(a) confers the arbitrator with the discretion to determine the rate of the interest, the period for which the interest to be paid, and the quantum on which the interest to be awarded. However, the discretionary power of the arbitrator is subject to the contract between the parties. 31(7)(b) provides the arbitrator the discretion to award interest for the post-award period. The discretion is not subject to any contract. If the arbitrator does not exercise the discretion by awarding post-award interest, then the mandated interest of 18% shall be awarded. Here in this case, Your Lordship, my interest portion, Your Lordship, is till the date of the publication of the arbitral award. So I will, Your Lordship, my case will fall into this.
So you want 18%?
As Your Lordship thinks fit.
No, I'm asking you.
Your
Because
Lordship,
the judgment mentions 18%.
yes, it's written, Your Lordship. Statute says 18%.
Statute, which one? 31(7)(a)?
Yes, Your P.
Arbitration Act দাও তো।
Mention 2% higher. It should be 2% higher than the awarded sum. It's 14. If I have got 14, it should be 16.
Yes.
And Your Lordship, regarding the maintainability of my
yes,
maintainability of my review application, on the first document, Your Lordship, when I actually moved it, Your Lordship asked me one question, that if you have shown, Your Lordship, the either consulting, Your Lordship, judgment at that point of time, the things are different. The Honorable Court has not actually considered. But if you have not shown, then in that case, how your review can be maintainable? You have to go before the Honorable Supreme Court or the Honorable Division Bench. But why review?
yes.
Lordship, kindly, Your Lordship, may I show Your Lordship this judgment on the Honorable Calcutta High Court. Paragraph 1. The petitioner seeks review of my order dated March 11, 2015, passed in WP number such and such. The writ petitioner has sought category A pay scale of primary school teacher in view of obtaining diploma in elementary education in terms of government circular number such and such. Lordship, kindly come to paragraph 6 in next page.
Yes.
I have considered the rival contention of the parties and materials made available on record. In Tinkori Sen, Supra, it has been held that overlooking a provision of law well settled beyond controversy furnishes a good ground for review, as it is an error apparent on the face of the record. In Amarjit Kaur, the Supreme Court set aside the order of dismissal of a review petition on the ground that the court did not express any view on the decision brought to the notice of the court. In the present case, the division bench judgment, which is binding precedent on me, was not brought to my notice at the time of the disposal of the writ petition. Consequently, I had taken a view in my order dated November 16, 2015, which is contrary to the view expressed by the division bench. In such circumstances, there is an error apparent on the face of the order dated 16 November 2015. In such premises, I find the review petition is maintainable.
Yes.
So therefore, Your Lordship, at that point of time, Your Lordship, the higher consulting this particular order, Your Lordship, was passed in 2021, and higher consulting, Your Lordship, was there at that point of time when, Your Lordship, the Section 36 application was disposed of.
Yes. So now you claim post-award interest, interest free, pendentility, and post-award.
Both, Your Lordship, paragraph 8, Your Lordship, I have shown, and Your Lordship, the Honorable Calcutta High Court judgment, Your Lordship, the subsequent judgments in your future retail matter, Your Lordship, the same situation arose, wherein Your Lordship has directed to secure the amount, future retail market, and subsequently review application was filed, that was dismissed. So two other on coordinate benches, Your Lordship, has taken the same view that Your Lordship, the not only the principal sum, but Your Lordship, the entire sum is
understood. Yes.
I'm grateful.
Your Lordship,
Microphone, please.
should we consider the 2023 judgment and come back? Because the higher and Your Lordship's view in future, we have 2023, I think.
Tomorrow.
Tomorrow.
Learned counsel appearing for the review applicant seeks review. Learned counsel appearing for the applicant seeks review of a judgment of an order passed by this court on 5th March 2021 in an application made by the respondent award debtor for stay of an award. What is the date of my
5th March 2021.
5th March 2021. In an application made by the award debtor for stay of an award, the award debtor was directed to put in an amount of rupees 1.30 crores with the registrar, which was the principal amount of indicated in the award. Stop. Next, counsel now prays for pre, pendent elite and post -award interest and relies on Hyder Consulting as well as other decisions of the Supreme Court in support of the prayer. Stop. Next, list this matter tomorrow, as prayed for on behalf of the respondent award debtor. Tomorrow, Monday. List this matter because tomorrow after 2 I will be difficult. On 8th January 2024, as prayed for on behalf of the award debtor.
Grateful.
I'm grateful.
Morgan Securities Gautam. Morgan Gautam. Hyder Consulting. Yes, call on the next matter.
10 Farm Development Private Limited.
May I, Lordship, come back on any time next week, subject to Your Lordship's convenience?
Why?
My section 11, Lordship, I should have got the decisions with me. I'm not carrying my phone.
Your section 11?
My section.
What decisions do you need?
Lordship, there is a checkered history in the matter. It started, an award was passed, went up till the Supreme Court, then again a fresh section 11. Lordship, I'll need.
Yes, I've written a rule. Any counsel who uses the word checkered history will be put to costs.
No, I don't. I don't use that.
Yes.
Anytime next week, subject to Your Lordship's convenience.
Yes, give me a date, please. Yes, Ms. Banerjee.
Tuesday, Wednesday, subject.
His application, my lord, there is a review pending, my lord.
Checkered history.
Not maintainable. That is my point.
Very good. List this matter on 10 January 2024 as paid for on behalf of the petition.
I live.
11 Mrs. Kapna Boido.
My lord, this is my application under section 11(6) for the respondent. My lord, dispute is, my lord, this is a partnership firm, my lord.
My microphone, please.
The petitioners before your lordship, my lord, are the partners. They are having 50% share, and the respondent also the partners, my lord. They are also having 50% shares.
Yes.
My lord, the dispute arose, my lord. The partnership firm acquire the commission of rupees 4 crore 11 lakhs.
Partnership?
Firm
Yes.
earned commission income 4 crore 11 lakhs. So after getting this commission income, my lord, the respondent siphoned away the entire fund and did not give us the partnership share of 50%, my lord.
Yes.
So that's why, my lord, there is no trust, faith, and confidence between the partners, my lord. So we issued the notice for the dissolution of the firm, my lord. So after the dissolution of the firms, they
Give me some dates, at least
Yes.
show me documents.
my lord, kindly come at page 32 of the volume 1, my lord.
$32.
My lord, volume 1, page 32.
Yes.
This is the partnership deed, my lord.
Yes.
Lord, then kindly come page 33, my lord.
What is the date?
The date of partnership is the 10th November 2008. This is the partnership date.
Yes.
Page
Then?
30. Then, my lord, kindly come page 33. Miss Manu Boitto, Obik Boitto, respondents there, and Shopna Boitto, Ratna Boitto, with the petitioners, my lord. We have the 25% share, total 50% share, my lord.
Yes.
Then we would kindly come page 34.
Yes.
Page 34, my lord, paragraph, clause 11, dissolution. That the partnership is at will. You got it?
Yes.
Partnership is at will and shall continue until the partners shall mutually agree to dissolve. Is a partnership at will, my lord. Then, my lord, kindly come page 36. Page 36, clause 18, my lord, is an arbitration agreement.
Yes.
This arbitration agreement subsequently amended between the parties and the modification agreement made and the dispute referred to a sole arbitrator. That is in
Already referred.
already agree. That's not coming. Page 39, deed of modification of the partnership. This modification will only in respect to the partners arbitration agreement, my lord. Page 39. Then we'll kindly come page 41.
Yes.
The testatum clause, clause A. In clause 18, the last paragraph, the arbitration agreement, parties agreed, matter referred to a sole arbitrator.
Yes.
Then we lord, kindly come at page 108 of this volume, my lord.
Yes.
Now, this is an arbitral reference dated 26th June 2016. This is a section 21 notice. There was a previous arbitration dispute between the parties. My lord.
No, in terms for the same disputes.
No, it's a different dispute.
Yes.
I am here different dispute. Well, this
So
dispute,
this is about 21 notice.
This is 21 notice. This I am hearing out referred to as the earlier reference.
Yes.
Well, this reference was with only regard to the clarification of the accounts. When the money come, then we clarify the account. They did not clarify it. Then I went to the arbitration. That award was there, my lord.
Yes.
For the clarification of the account. My lord, then come, my lord, 110, my lord, the second volume. Well, this is an award with regard to the earlier arbitral reference.
Yes.
Well, straightway, well, kindly come page 163, the operative part of this award.
Yes.
This is point number 70. Is the award. So the partnership firm exists between the parties, my lord. Partnership firm has not been dissolved, although it was not the prayer in the earlier arbitral proceedings. My lord, after this award was passed.
What is this travesty of justice?
That was some, my lord.
You were the claimant.
I was the claimant over there, my lord.
Yes.
So since the initiation of the earlier arbitral proceeding was only with regard to the clarification of account, so the accounts has been submitted. From that account, we came to know there the serious malpractice happened, my lord. Thereafter, we issued the dissolution of the firm. The notice of dissolution is paid.
What is the date of the award?
Date of the award is, my lord, as 5th May 2022.
Yes.
My lord, then kindly come page 176, my lord. So that after getting all accounts from the arbitral proceedings, so we dissolved the firm by the letter dated 30th June 2022.
Yes.
Lot 176.
Yes.
This is the dissolution of the partnership firm. So let kindly come 186.
Yes.
So the first two paragraph, last two paragraphs, my lord. In such view of the matter, there is no faith, trust, and confidence subsisting among the partners of the firm. There is no scope of the settlement of dispute amongst the parties of the said firm mutually. It is not possible to continue. These are the, my lord, I pray. That's why I prayed for dissolution of the firm with effect from 30th June 2022 and claim the accounts of the firm, my lord. Claim the accounts of the firm with interest thereof. Whatever the accounts will come, that after dissolution, I'm entitled for that because I'm the 50% shareholder, my lord, of the firm. They would kindly come. They have received the dissolution notice, my lord. Well, after receiving the dissolution notice, they have issued, they have withdrawn the money from the partnership firm without our consultants, my lord, that is there. There was 39 lakhs money was deposited, that keeping aside 15 lakhs, money has been withdrawn, my lord. Then kindly come, my lord, page 190. What is the reply to the dissolution firm?
Yes.
And I'm just reading, my lord, last paragraph. Moreover, it is our decision whether to be part of our company, is the firm. I and my son, Ovik Boitto, who is also partner of this company, will remain and run this company to fulfill all necessary obligations. So it didn't come for the dissolution of the firm or accounts. Then, my lord, I issued the notice. The second arbitral reference, hereinafter referred to page 191, my lord. Now, this section 21 notice, 20th July 2022, my lord, page 191.
Yes.
Lord, my prayer in this notice, my lord, kindly come page 201.
Yes.
201, last three paragraphs, I have stated, in the aforesaid circumstances, my client by their letter dated such and such dissolved the said partnership from BHATTACHARYA Forum Directors India with effect from 13 June 2022 and claim for the accounts of the firm and also demands from from you for the payment to so and so. Such and such, you have received the letter and such answer. Then what is the reply of this, my lord? Section 21 notice. 202, my lord.
Yes.
202 is a prayer, and then Lord, 205 is the reply. This is interesting. This is, my lord, I would like, my lord, got it, 205?
Yes.
I would like to inform you that our arbitration with the aforementioned case number has been concluded and award published on such and such date by the learned sole arbitrator, Mr. Such and such. So there is no requirement of another arbitration as there is no matter to adjudicate. Your clients can accept the awarded amount and dissolve their part of the firm. So the dispute is lies, my lord.
Yes.
Now, my lord, their only contention, my lord, res judicata.
Yes.
Lord, the last occasion, my lord, I have submitted one judgment, my lord. That is, my lord's brief.
Yes.
2011, 3 SCC, 507,
Yes.
paragraph 16.
507. তখন
Paragraph 16, Madam Referee. The question whether claim is a barred by res judicata does not arise for consideration in a proceeding under section 11 of the Act. Such an issue will have to be examined by the arbitral tribunal. A decision on res judicata requires consideration of the pleadings and also claims, issues, points, and the award in the first round of arbitration in juxtaposition with the pleadings and the issue, points, claims in the second arbitration. So that's my the issue. That's my submission. Or I'm paying for the appointment of the arbitral. My claim is 1 crore 7 lakhs principal plus interest.
Yes, Mr. Dashgupta.
Before I start, may I file my affidavit in opposition?
Yes.
Served long back.
Yes. Reply is on record?
Yes.
Yes. Move the microphone. I can't hear you.
Well, so far as the question that it has been argued that the first arbitration was so in respect of the clarification of the accounts, and therefore after the accounts are clarified, they got to know that there are dues. So now the second arbitration proceeding is to be initiated in order to get the claims. Now, in my affidavit in opposition, I have disclosed the statement of claim, and award is also on record. Now, kindly comes to page 78 of my opposition, the statement of claim, and I'll be showing you lordship the prayers.
Mr. Dashgupta, I'm not with you. I will allow the application, and I will appoint the same learned arbitrator to decide the dispute.
I thought of it, Millard, because I just
same learned arbitrator who had earlier given the award, pronounced the award. I will appoint the same learned arbitrator for deciding the dispute.
I will not.
Res judicata in section 11.
I will not trouble you, lordship, with res judicata is one of the points. But may I just indicate? I'll show you three things, Millard.
Just tell me what those are, because I'm not with
First is, Millard, what was claimed, and this 1 crore 62 lakhs, the amount that is shown now, exactly that very amount has been adjudicated.
Very well. Let the arbitrator decide the point of res judicata. Let him decide.
Because then, in that case, I have to again go for evidence. Say, I have to bear the cost of.
If it goes against you, if that decision goes against you,
but the process of adjudication will not involve evidence. Again, the same set of evidence.
No, I'm not with you. Any other things you want to say?
But second, the other thing is that point of order to rule 2. That in the first option when they come to court, they
not relevant. Next.
And third is it's hopelessly barred by limitation.
Barred by limitation. What is the date of the award?
Not the award. They are claiming money from 2016.
Absolutely not.
So 2016
siphoning and dissolution, subsequent events.
That's not the case in the application.
Let the arbitrator decide that.
Same arbitrator.
Yes. The dispute between the parties is apparent from the facts placed on record. Stop. The petitioners own 50% of the partnership assets, while the respondents own the remaining 50%. Stop. It appears from the records that the petitioners had made an earlier invocation of the arbitration clause contained in the deed of partnership dated 10th November 2008, later modified to 18th September 2018. Have I got the dates right, or what? What is it? 10 years difference between the two?
Yes. The second one was executed after the initiation of the first arbitration.
Very well. Ki bola? Sentence to? Stop. The first invocation notice was of 24th June 2016, where the petitioner claims that the petitioner sought for clarification of the accounts. Stop. The what is 5th May 2022? The reference, the invocation led to an award dated 5th May 2022. Stop. The petitioners, however, found that the respondents had siphoned, SIPHONED, siphoned monies, MONIES, monies from the partnership account subsequent thereto and issued a notice of dissolution of the partnership on 30th June 2022. Stop. The petitioner what is page 190?
That's our reply.
Yes, the respondent replied on 15th July 2022. Conceding to the dissolution and intending to and expressing their intention to continue with the partnership business. Stop. Next, the petitioner invoked the arbitration agreement for the second time on 20th July 2022. And the respondent replied on 19th August 2022, referring to the award of 5th May 2022, stating that the disputes between the parties had already been decided by the learned arbitrator in terms of the award. Stop. Next, the only question which arises before the court is whether the application should be disallowed in view of the earlier reference and the award passed by the learned arbitrator. Stop. While the petitioner, through learned counsel, petitioners, through learned counsel, say that the second reference is with regard to new disputes, learned counsel appearing for the respondents disagrees with the contention, with such contention. Stop. Next. It has now been conclusively settled. It has now conclusively been settled that considerations of res judicata are irrelevant to an application made under Section 11 of the 1996 Act for appointment of arbitrator, refer Indian Oil Corporation versus SPS Engineering 2011 3 SCC 507. Stop. In that decision, the Supreme Court opined that the limited scope of Section 11 of the 1996 Act does not permit examination of the maintainability of a claim either on facts or in law, and that the arbitral tribunal should decide whether the claim was barred by res judicata. Stop. Next, in the present case, apart from a dispute existing between the parties, which is relatable to the arbitration agreement, There is also a fresh notice of invocation under Section 21 of the 1996 Act, dated 20th July 2022. Stop. The question whether the petitioner is once again, petitioners are once again raising stale claims, S-T-A-L-E, stale claims, or ones which have already been decided by the learned arbitrator, is a question which is not for the court, but for the learned arbitrator to decide. Stop. Next, AP 697 of 2022 is accordingly allowed and disposed of by appointing Mr. Rajratno Sen, counsel, to act as the arbitrator for resolving the disputes and differences between the parties, subject to the learned arbitrator communicating his consent in the prescribed format within 3 weeks from the date of communication of this order. Stop. It may be mentioned that Mr. Sen was also the arbitrator in the previous proceedings between the same parties and would hence be best suited to decide the question. The questions raised before this court. Stop. Next, the advocate on record, the petitioner, will communicate this order by 6th January 2024.
One liberty, Milord. If I be permitted to, Milord, raise the issue of, Milord, res judicata as a preliminary issue before the learned arbitrator, Milord.
Yes, needless to say, comma. That is what the order says. Can't you understand? Needless to say, comma. I've said that the court can't decide, the arbitrator can. So what?
Preliminary issue.
Needless to say, comma, the respondents will be at liberty to take the point of res judicata as a preliminary issue in the arbitration.
Great.
I don't use the word preliminary because it's a tongue twister for me. That's why. Yes. Call on the next matter, please.
Item number 12, SK Petro Services.
May it please your ladyship, this is my application under section 11
For the
for
respondent
appointment of
number
an
1,
arbitrator.
I'm being laid by Mr. Shutushokta Banerjee in the matter. Mr. Banerjee is on legs before court 9. However, my learned friend was making submissions. May he start? I shall take notes, and in the meantime, he shall.
Now that I have your sanction, Mr. Medora can continue.
Lordship, I apologize. That is not.
Yes, yes.
My lord, I'll indicate, my lord, what the respondent number 1's defense is before I place my case on merits. The respondent number 1's only defense.
Mr. Medora, just pick up the thread first, please.
I beg your pardon?
Pick up the thread first. The thread of the matter.
The thread of the matter is this, my lord. The respondent number 1 is contending that there is no privity between the respondent number 1 and the petitioner.
Yes.
And consequently, there is no arbitration clause between the parties. That's the only defense which they've taken in their opposition. I will indicate that in due course of time. So far as the facts are concerned, my lord, the petitioner participated in an e-auction conducted by the respondent number 2, which is MSTC. And this e-auction was conducted by MSTC on behalf of NTPC.
Yes.
So in other words, MSTC was acting as NTPC's agent for the purposes of carrying out this auction.
Yes.
This e-auction, my lord, was conducted on the 1st of September 2021.
Yes.
It was in respect of scrap materials which were to be sold by NTPC.
Yes.
I participated in this e-auction and I was chosen as the highest bidder, and the amount which I had bid, my lord, was 5 crores 39 lakhs 71,681. Thereafter, a letter of acceptance was also issued in my favor on the 10th of September 2021. Now, so far as these scrap materials were concerned, my lord, they were supposed to be sold to me in 3 lots. I deposited an EMD, earnest
So
money
the
deposit.
respondent would sell the material to you?
Yes, NTPC, the respondent number 1, would sell this material to me. I would be the purchaser. MSTC was merely acting as a conduit, as the agent of NTPC.
Yes.
I deposited, on being successful, I deposited an EMD, earnest money deposit, of rupees 51,22,840 in respect of these scrap materials, which were to be sold to me in 3 lots. 1 lot of materials I paid for, and I obtained the materials. So far as the other 2 lots were concerned, my lord, I was to make payments for them and thereafter receive the materials. There were certain technical issues with regard to me paying the money, depositing the money, etc. I sought an extension from the respondents. Certain extensions were given. Thereafter, unfortunately, they refused to grant me further extension of time. And ultimately, NTPC.
So they were to sell and you were to buy?
Purchase, yes.
So what extension?
To make the payment for these scrap materials.
So you were to make the payment and
make
they gave you extension?
Yes. Ultimately, my lord, they claimed, the respondent number 1 claimed that there was a delay on my part in making the payments so far as the balance 2 lots were concerned. And my EMD to the extent of 34,52,290 was forfeited.
No, you said 51 lakh.
That was the entire, for 3 lots.
Yes.
1 lot, payment made, full payment made, materials received.
34 point?
34,52,290.
Forfeited.
Forfeited.
Yes.
And this is where the dispute is, man. My contention is, A, this EMD should not have been forfeited. My contention is...
So your claim is to the extent of 34 lakhs.
So far as the EMD is concerned, I also have a claim of damages, about roughly 1,25 lakh.
Yes.
And interest. So roughly, my lord, without interest, my lord, my claim is about 1.6 crore.
1.59.
1.56 crore.
Yes.
So, my lord, these are, my lord, roughly the facts of the case, my lord. I sent a section 21 notice. I'll place those documents, my lord. The respondent number 1 responded to it by saying that there is no arbitration clause between the 2 of us. There is no privity of contract. In my respectful submission, a completely dishonest stance. So far as the respondent number 2 is concerned, MSTC, they really have nothing to do with the matter as such, perhaps. So they just sent a bare denial. And they're not even participating.
No, but why would respondent number 1 say that there is no privity between the both?
That they'll have to explain themselves. From what I've been able to understand, my lord, is that they claim that any arbitration clause contained in the tender document will constitute an arbitration clause between MSTC and the petitioner.
And the arbitration clause says that?
No, it doesn't. It doesn't.
Yes.
And in any event, even if it did say that, I would say it's still binding on NTPC. So, my lord, kindly permit me to place firstly the arbitration clause.
Mr. Medora, quickly, then I can keep it on some other day to hear Mr. Banerjee.
I'll finish my submissions today, my lord, because I'll show some judgments also. And then
on which point?
On several points, my lord. One is, my lord, I will show a Delhi High Court judgment on the point that an arbitration clause in respect of a contract between the agent of a party and a third party is binding on the principal, which is my case here. Even if it's even assuming the arbitration clause is between MSTC and me, it will still be binding on NTPC because NTPC is the principal. They have received the money. They have received the EMD. They've sold 1 lot of materials to me. They've enjoyed the benefits of the contract. And now to shy away from the entire transaction and saying there is no privity of contract between the 2 of us is a completely dishonest stance. The second proposition, my lord, which I will place before your lordship, for which also have a judgment, my lord, is on the point of estoppel. If a party has enjoyed the benefits of a contract, it cannot now subsequently contend that there is no privity of contract between the 2 parties.
Yes.
Then, my lord, in a similar situation, my lord, I have a case, my lord, for an arbitration clause in a tender document is also a valid arbitration agreement. So it's not necessary that the arbitration clause or the tender document has to be signed by both the parties. Yes. Because that could be another ground which they may take, that they have not signed any arbitration agreement or any contract as such.
Yes.
And the third proposition, my lord, will be, my lord, the arbitration agreement can be spelled out from correspondence, need not be signed, and there must be a pragmatic approach and not a technical approach so far as the point.
That is section 745 anyway.
Yes, especially in commercial. May I quickly show, my lord, the relevant documents? From
No,
the...
no. You will only show the judgments and and give me the paragraph numbers. That's all.
No, the documents are the arbitration clause.
Only the 21 notice and the arbitration clause and their reply. That's all.
I can show the forfeiture also if your ladyship is desirous, but may I first place the arbitration clause, which is part of the buyer-seller terms and conditions, which commences at page 26. Buyer specific terms and conditions.
No, how is that relevant? Just show me the arbitration clause.
Yes, that is the page which has the arbitration clause. Page 26.
26.
Clause 3, my lord, titled arbitration.
Yes.
In the event of any dispute or difference relating to the interpretation, terms, application of the provisions of the contract, such dispute or difference shall be referred by either party for arbitration to a sole arbitrator to be appointed mutually by the parties. In case parties fail to appoint the sole arbitrator within 30 days of the invocation of arbitration, the same will be appointed as per the provisions of the Arbitration and Conciliation Act 1996 as amended. The language of the arbitration shall be English. The place where the concerned office of MSTC conducting the auction event is situated shall be the venue of such arbitration proceedings. The cost of the arbitration proceeding will be borne equally by the parties to the arbitration. The award of the arbitrator shall be final and binding on the parties. The jurisdiction clause, is at page 24. Actually, at page 26 also, clause 4 also talks about jurisdiction. Page 24, my lord, also has a
no, but there is no problem with jurisdiction. Yes.
Kindly, my lord, see one document, my lord, which is, my lord, at page 31.
Yes.
Which is the letter of award. Kindly see, my lord, the names of the parties, my lord. This is issued by MSTC. Acceptance letter, sale order details. Buyer details, my lord, on the left-hand corner, my lord, on the left-hand side, is the petitioner, my lord, SK Petro Services Private Limited. Kindly note, my lord, on the right-hand side, the seller details. NTPC Kehelgaon.
Yes.
So it's a contract which I'm entering into with them. And the date of the auction is mentioned. The auction number is also given. Kindly turn over to the next page, my lord. Page 32, towards the bottom of the page, the last paragraph. You are requested to deposit INR 5,39,71,681, including TDS, by way of e-payment DD/PO, favoring NTPC Limited, as per payment terms or special terms and conditions for the above lots by 24th September 2021. Balance amount of so-and-so is to be deposited by way of e-payment. And the next remark, which is there also, I place reliance on this. An amount of rupees 51,22,840 towards EMD/SD received in MSTC account, which will be forwarded to principal/seller, that is NTPC, shortly. Balance material value except MSTC service charge should be deposited in favor of seller bank account as mentioned in auction catalog. Now, my lord, one last document before I proceed to the judgments, my lord, or two last documents, my lord. Kindly see the forfeiture, my lord, the letter of forfeiture, my lord, which is at page 55. This is an email sent to me, my lord, by NTPC. The name of the concerned personnel of NTPC is mentioned at the bottom, A.K. Gupta, the Additional General Manager, NTPC Kehelgaon. Kindly permit me to place the first paragraph of this email. Please refer to trailing email dated 8th February 2022 of MSTC Patna.
Mr. Medora, let me read.
I'm sorry.
Yes. Does it mention the amount which is forfeited?
No, it does not specifically mention the amount, but it refers to the EMDs. There is no dispute about that.
Yes. Very good.
So, my lord, NTPC is making me forfeit the security deposit or the EMD which I deposited. Now, my section 21 notice is at page 85. It was sent by me, my lord, on the 7th of October 2022.
Reply?
Reply, my lord, there are two replies to this. The first reply is at page 121, which is, my lord, NTPC's reply. I'm sorry, this is, my lord, MSTC's reply. It's just a bare denial. Kindly see, my lord, the penultimate paragraph at page 122. With reference to the statements and or allegations made in para 16, 17, and 18 of your letter under reply, our client denies that there is any dispute or difference exists in respect of the e-auction process as alleged or at all. Thus, our client is not in concurrence for appointment of so-and-so as suggested by your client and mentioned in paragraph 17 of your letter under reference. So this is, my lord, MSTC's reply, and NTPC's reply, my lord, is at page 111. October. So reply to the legal notice dated 7th October 2022, which is my section 21 notice. Kindly, my lord, turn the page over, my lord, to page 112. Paras 2 and 3, 2, 3, and 4, my lord. These are the three paragraphs I placed reliance on, my lord. May I place these paragraphs? Para 2, my lord.
No. That's enough. You come back on some other day
and, the judgment
and conclude that by showing your judgments. How many do you have?
I think 4 or 5 judgments.
On one for each point.
Yes. I will not, as in I have more on each point, but
Yes,
I will not
and just exchange it. Whatever judgments you have, please exchange on the next case where you can conclude, both of you. All right.
May I show the opposition once, just to, before I move on to the judgments? I'll just show their opposition so far as their stance is concerned. And I will kindly take their opposition, just one paragraph at page 3.
Yes.
Para 3, my lord, at page 3.
Yes.
I have been advised to deal with only those allegations and contentions and or statements which are material for the purpose of disposal of the said section 11 application, and the remainder will be presumed to have been denied and disputed in seriatim. Before dealing with the allegations contained in the said section 11 application, I state that there is no valid or enforceable or existing arbitration agreement between the parties for reference of the purported disputes to arbitration. And in any event, there is no contractual relationship between the respondent number 1 and the petitioner herein. The foundational basis for invoking jurisdiction under section 11 of the Act of 1996 is thus absent. This is their only defense, subject to what my learned friend may say in his reply.
Very well. Mr. Medora, please give your decisions to Mr. Banerjee and you, vice versa. When would you want to come back? Just for the decisions, and then I will hear Mr. Banerjee.
But I could come back, my lord, on the 10th of January, subject to
10th. Yes. Learned counsel appearing for the petitioner has taken the court through the relevant facts and pleadings, facts and documents. Stop. Counsel submits that the respondent number 1 is a principal, and the respondent number 2, that the respondent number 1 NTPC is a principal, and the respondent number 2 MSTC is conducted the e-auction pursuant to which the petitioner was awarded the contract for purchase of material, a scrap material from the respondent number 1. Stop. Counsel submits that the respondent number 1, NTPC, forfeited rupees 34.52 lakhs of the rupees 51.22 lakhs of the EMD put in by the petitioner pursuant to the terms of the e-auction. Stop. The petitioner invoked the arbitration clause contained in the
buyer specific terms and conditions.
Yes, contained in the capitals buyer specific terms and conditions within brackets BSTC close brackets on 7th October 2022, and both the respondents replied to the same in October 2022. Stop. Next, list this matter on, you said 10th?
11th, my lord.
On 11 January 2024, as prayed for, to hear both counsel appearing for the petitioner as well as for the respondents. Stop. Who is for MSTC? Nobody.
Nobody's been appearing, my lord. We have served them. Yeah,
Respondent. Stop. Next, MSTC is not represented today. Next.
I'm grateful, my lord.
Matter number 13 to 20 in the goods of Honorable Chamria.
Yes.
My lord, most are my applications, my lord, in these list, my lord. Item number 20 is the item number 20 in the list, my lord, is the contempt application, where your lordship, my lord, had been pleased to pass an order on 16th of October 2023, my lord. This is the order which your lordship had been pleased to pass. This order has not been complied with. Your lordship, my lord, will take the last page, page 9, paragraph 15.
Yes.
This court is therefore of the view that the petitioner has established a fit case whereby the alleged contemner should be called upon to deposit the amount of 88,70,000 as disclosed by the two sale deeds with the registrar original side of this court within 2 weeks from date. The alleged contemner shall file an affidavit of compliance with this direction on the next date, that is 17th November 2023. No such affidavit of compliance has been filed. That's, my lord, my number 1 point. My lord, your lordship will take a decision what has to be done there. Now, my lord, so far as my applications are concerned, my lord, in this list, my item number 15 is my application for further orders.
Yes.
My lord, GA3. My lord, I'm seeking for further orders here in, my lord, two things. My lord, one, I'm asking, my lord, injunction or, my lord, a direction on them to deposit the entire sum which they have received, which is around 6.6 crores odd.
So what is 88 lakhs?
My lord, 88 lakhs is, my lord, with regard to one of the properties which was sold between 1st July 1st and 9th of July, my lord.
Yes.
But prior to that, they have sold properties which is worth around 6 crores plus. So, my lord, direction to deposit that entire money. And secondly, and most importantly, I'm asking, my lord, for a receiver to be appointed to go and take actual physical possession of the entire property. My lord, circumstances which have, my lord, that's my prayer in GH.
And what is the ground on which you're seeking these prayers?
Well, the property admittedly is part of the estate of the deceased. Well, the probate application is pending here. The property is being dealt with, which is also a matter of record. And subsequent to, my lord, the orders which have been passed, well, they have also, my lord, tried to deal with the property in the sense, my lord, construction is going on, some other work is going on in the property. So, my lord, considering the, my lord, the conduct of the respondent here, my lord, an injunction is necessary to be passed, and injunction directing the money to be deposited necessary to be passed, and most importantly, receiver to go and take actual physical possession and see what is the status of the property. It's a huge property. It's 100 odd acres in Mussoorie, and around 11 odd acres is what has been sold so far. So 90 acres is still very much there.
Yes.
My lord, may I please, my lord? In the contempt application, I'm seeking, my lord, rule be issued now, my lord, and directions be made because they have not deposited, my lord. My lord, if your lordship takes, my lord, I must say, my lord, they had filed also an application which is GA6, which was for vacating of the interim order which your lordship has passed on 1st of July 2021. Their only ground, my lord, for vacating is the fact, my lord, that this court, that they have a prior will, and a prior will does not require registration, or it does not require a probate, and that is why they could have dealt with the property, and that is why they are dealing with the property. Therefore, there should not be any order of injunction on them. That is their only ground for asking for vacating of the interim order. The case they have made out is because the property is outside the jurisdiction of Bengal. Therefore, my lord, Section 213 does not apply. Probate is not necessary. But that is not the case, my lord, because there are two properties here. One is a property which is in Mussoorie. There's another property which is in Salt Lake, which is in Bengal. So, my lord, probate would be necessary, but that is immaterial because here the fact is the will which I am seeking probate of is the later will, and the later will, if probated, will, well, the first will, my lord, has no significance whatsoever, my lord. So, my lord, if your lordship takes, my lord, my application GA3 of 2021. That is.
Yes.
Well, your Lordship will find at page 37. Well, this is the will which I am seeking probate of. Page 37 of this application.
Yes.
My lord, in the second paragraph at page 37, my lord, he also says, my lord, I hereby revoke all my earlier wills and testament, including the will dated 14th March 2018. This is the will which my learned friend is relying upon, the prior will.
So this is the will you're relying on.
Well, I am relying on the will. Yes, my lord. This is the will I am relying on, page 37. This is a will, my lord, which is dated, my lord, 14th December 2019.
Yes.
My lord, will kindly take page 85. My lord, after I filed my probate application, I also took out an application for injunction. This is the order which was passed by your lordship at first instance. My lord, page 85.
Yes.
This is an application by the executor to the last will and testimony of Mr. late Chamarya, who left behind a will dated 14 December 2019. The probate proceeding in relation to the said will, being PLA 88 of 2001, is presently pending in this court. The learned counsel appearing for the executor, who also happens to be the cousin of Anirudh Chamarya deceased, prays for urgent orders in view of certain facts which are relevant to this application. Counsel submits that deceased has several properties both in Kolkata and in Mussoorie, Uttarakhand, by reason of which probate proceeding has been filed in this court. Counsel places sale deed in relation to property situated in Uttarakhand and names one Neeraj Khanna as the vendor. Sale deed further shows that the vendor Neeraj Khanna has relied on a will dated 14th March 2018, which was registered at Dehradun, by reason of which Neeraj Khanna became the exclusive and true owner of Radha Bhavan Estate, Mussoorie. Counsel further submits that Neeraj Khanna has also been named in an application filed by a tenant of Radha Bhavan Estate in Dehradun court, contains avowment that Neeraj Khanna has expressed interest in the proceeding taken out by the tenant, and further that Neeraj Khanna is not related, I think, related to the deceased. The application also states that the earlier will, which is being relied upon by Neeraj Khanna dated 14th March, is surrounded by suspicious circumstances. Upon hearing the learned counsel, this court is of the view that correctness and the circumstances under which Neeraj Khanna is claiming under a different will can be gone into at later stage of the proceeding. The admitted position as of today is that there is a pending probate proceeding which has been filed by the applicant, who is the executor of the later will dated 14 December 2019. Significantly, the said will revokes all earlier wills and testaments and appoints the applicant as the executor. The will dated 14 December 2019 further states that the earlier will dated 14 March 2018 has been executed under the influence of Neeraj Khanna. These are the facts which are before the court today. The fact that the probate court has inherent powers to pass an order of injunction for protection and preservation of the properties which are subject matter of the pending probate proceeding has been upheld in Priyamvada Devi Villa versus Lakshmi Nagar. By reason of the above, this court is of the view that there should be an interim measure of protection for preserving the properties which form the subject matter of the will dated will PLA 88 of 2021. There shall accordingly be an injunction restraining Neeraj Khanna from selling, dealing with, or alienating Mussoorie property and Salt Lake properties of the deceased. There shall be an order in terms of prayer A of the application. Let special citation be issued. Well, this was the order which has been passed. Now, my lord, if your lordship takes page 109, my lord. My lord, I have given particulars, my lord, of all the sales which have taken place, sales or gifts which have taken place. Your lordship will find, my lord, there are approximately 23 deeds. No, there are 23 deeds. Most are sale. Serial number 15 and serial number 23 are gifts. Well, the gifts have also been made to relatives of the said Neeraj Khanna only, my lord. Like if your lordship sees 15. 15 is a gift made to Namita Khanna, which is the wife of Sri Neeraj Khanna.
Yes.
And my lord, altogether, the area which has been sold so far or dealt with so far is around 12,000 square meters. And total value of the transaction is 6.18 crores. My lord, the two properties in relation to which your lordship had directed a deposit of 88 lakhs is serial number 21 and 22. 17 lakhs and 71 lakhs. These two properties, my lord, were sold after 1st of July 2021. That is why, my lord, for the time being in GA3, your lordship had directed deposit of only these two properties, sale proceeds from these two properties. My lord, all the sale deeds, my lord, I've craved leave and I've got copies of all the sale deeds, my lord, which have been executed by Neeraj Khanna. I have craved leave to rely on them.
So this
have all of
is
them.
in aid of your prayer, your second prayer, that they
Yes,
should hand up the entire amount.
Yes, my lord. Hand up the entire amount and also
So that
for the
is
receiver to be
pre 1st July.
Pre 1st July also. 1st July, my lord, your lordship, I'll take your lordship to the order which was passed. Order ta kothay ache? Your lordship, give me 1 moment. Now, my lord, your lordship, when GA3 was moved for the first time, at the ad interim stage, your lordship had passed an order of 16th February 2022, which is part of the contempt application. Contempt application ta karte hain? On page 105 of the contempt application. On page 105.
Yes.
The executor to the last will and testament of late Shri so-and-so seeks further protection in terms of an order passed by this court on 1st July 2021. The 1st July order should be read as testament and not testimony. By the said order, an injunction was passed restraining Neeraj Khanna from selling, dealing with, alienating the Mussoorie property and Salt Lake properties of the deceased. Neeraj Khanna was named as the vendor in the sale deed in relation to a property situated in Uttarakhand. The basis of the injunction would be apparent from the order and hence it is not repeated. Learned counsel for appearing for the executor places documents showing that parts of the Mussoorie property have been sold to various persons by Neeraj Khanna, including the wife of the said Neeraj Khanna. The particulars given in the documents show that the sale and or alienation commenced from October 2020 and continued till 6 July 2021. Learned counsel for Neeraj Khanna submits that Neeraj Khanna became aware of the order of injunction only on 9 July and some of the properties had been alienated between 1st and 9 July amounting to rupees 1 lakh. Council also urges that Section 213 of the Indian Succession Act would not apply to any property in Mussoorie. Without going into further merits of the matter, pending affidavits, Neeraj Khanna is directed to maintain status of affairs as existing on 1st of July 2021, which is the date of interim order passed by this court. Any amounts received by Neeraj Khanna from sale or alienation of Mussoorie property shall be kept with the registrar original side of this court. The amount should be deposited within a week from date. Neeraj Khanna is also restrained from taking further steps in relation to properties which form subject matter of injunction in the order dated 1st July 2021 until the matter is heard on affidavits or until further orders, whichever takes place earlier. The amounts to be deposited by Neeraj Khanna should pertain to sale of Mussoorie properties after 1st of July 2021. So now, my lord, I'm seeking for the orders in relation to prior to 1st July 2021 as well. And most importantly, now, my lord, also seeking an order for a receiver to be appointed.
And do what? Take actual physical
possession of the entire property, my lord, and give a report and showing what is the status of the property, whether any tenant has been inducted.
Yes,
what is
Mr. Medora, why have you not complied with the direction?
So far as your ladyship's
order in the contempt application is concerned, my lord, that we have filed an appeal against this order that is likely to be listed next week.
We have not been served with any appeal.
We have filed it, my lord. The appeal is also numbered. No caveat had been filed, which is why possibly they have not been served. But we can serve them, my lord. It is likely to be listed, I'm instructed, on the 10th or 11th of January. That is the reason, my lord, I have not filed my affidavit of compliance.
That is no ground, my lord. There's no order of stay.
I-
And 17th of
Very well.
November, my lord, they were supposed to comply with.
Mukherjee, I will do this.
Yes, my lord.
Next week, I will keep the matter since Mr. Medora is saying that it's going to be listed next week.
On 10th or 11th.
On
10th or 11th, one of
10th
these
or
two
11th.
days.
I will keep the matter on 15th. All right. 15th, and then if there is no stay, nothing, I will proceed with your application.
Yes, my lord. My application, my lord, anyway, my lord, the appeal is from the order of contempt, my lord. My GA3, so far I'm seeking for further orders, my lord, that there is no, my lord, there's no reason for not to proceed, but I'm okay, my lord.
You
I'll
come back on 15th, and I will record that.
Yes.
Yes. Learned counsel appearing for the petitioner begins his submissions by pointing out that the respondent / alleged contemnor in CC 11 of 2023 has failed to comply with the direction contained in paragraph 15 of the judgment. Stop. The judgment was passed in CC 11 of 2023. Stop. The judgment referred to was passed in CC 11 of 2023. Stop. Next, counsel seeks further orders in terms of the prayers in terms of prayer B of GA3 of 2021 for
Also C1, where B and C.
prayers B and C of GA3 of 2021, including for appointment of a receiver to take actual physical possession of the entire estate of the deceased, which is now enjoyed / occupied by Neeraj Khanna. NEERAJ, Neeraj Khanna. Stop. Next, learned counsel appearing for Neeraj Khanna submits that the representing lawyers have challenged the judgment of 16th October 2023, and that the appeal is due to be listed next week. Stop. Next, in view of the submission made, list this matter on 15th January 2024. Stop. Next, it is clarified that the appeal relates to the judgment passed in the contempt proceedings, is restricted to the contempt proceedings, that the appeal is restricted to the contempt proceedings and not on the further applications made for and not on the other applications made for further prayers. Stop. Can't hear you, Mr. Ghosh.
I appear for the applicant in GA number 5. This is for issuance of special citation. I am the half brother, Millard. There is one other application.
Who?
Half brother of Millard, the original person, Millard. So if I am there.
Forgotten his name.
Millard Anirudh Maria Millard. Now, Millard, if I am successful, Millard, then Millard, everything automatically should come to me. So I should have been cited. The application for discharge of caveat, my caveat is on board, Millard. I want, Millard, the special citation to be issued, Millard, on me, Millard, or my client, Millard. Secondly, I also have an application, GA number 8 of 2023, for, Millard, deposit of whatever amounts, Millard, has been, Millard, fetched from those sales to be deposited in an escrow account.
So far as that application, I'm
GA number 8.
I'm also
And
supporting my
Mr.
learned
Mukherjee has filed an application for discharge of my KVA. So, my lord, GA number 5, if it can appear in the list, my lord, it's a
Yes,
it's a
list
connected
these
matter.
applications along with GA5 of 2021, comma, which which has been filed by the what is the technical word? Half brother.
Half brother.
Half hyphen brother of the deceased, comma, Anirudh Chamriya, for issue of citation. Stop on the return date. On the return.
So far as these applications are concerned, my lord, directions for affidavits have not been given. Mr. Ghosh's applications, will maybe be permitted to file our affidavits.
GA5.
GA5 and
GA5, I want citation. My KVA is on board, my lord. There's an application for discharge. So far as GA number 8 is that there, my lord, that deposit of the entire amount by Mr. Medora's client to an escrow account, my lord. That I have an ad interim prayer, my lord. That has to be deposited. Until this is decided, he cannot have that.
You cannot
praying
have
for
what?
directions from
Affidavits.
I have, my lord, the entire money, my lord. The money has been taken.
Entire property, my lord.
Very well. Let there be an order for affidavits in GA5.
Yes, yes.
Yes.
5 and 8.
Next.
8, my lord, I'll be placing, my lord. It was not heard.
Yes. Let affidavit in opposition, comma, as prayed for, comma, be filed in GA5 of 2021. Within how much time do you want, Mr. Medora?
10 days time, my lord.
Within 10 days from today. Reply within
7 days.
7 days thereafter. Stop. List GA5 of তাহলে যেটা বললাম returnable date টা হবে না. List GA5 of 2023 after on 30th January 2024.
Wait.
The other application will be coming up.
Yes, next day. I'll be pressing.
Yes.
Grateful.
Mr. Mitro, you are appearing for
The next two matters are allied. The
Item number 21 and 22, Jindal ITF Limited.
well, there are there are 34 applications from an award, unanimous award of 3 arbitrators. The other side has filed a 34 application and my affidavit is there. We have also filed for not getting the entire amount of compensation as we had claimed.
You're the claimant.
I was the respondent counterclaimant. There was an award in my favor, rejecting the statement, the claimant's case, and award of 40 odd crores in my favor.
So your counterclaim was dismissed.
Allowed, partly allowed.
Partly
Claim dismissed entirely, counterclaim partly allowed.
My lord, I am appearing on in item number 21 as petitioner and in item
We
number
can,
22.
whenever Lordship fixes it for hearing, because the affidavit oppositions are given. Reply is
Opposition-
really in a 34 affidavit reply, Lordship, that is not really necessary because
As per last order, my lord, on 19th October, there is a direction to file reply within 22nd of December. But we received the opposition on 20th of December. So we required another 3 weeks time to file our reply.
So you received it before time?
No,
20th December.
20th December.
Yes.
19 December.
Very well. Yes.
So can we probably both of they also
How
require.
much time do you want?
I want time, my lord, to file our reply.
How
3
much?
weeks time. 3 weeks time, at least 3 weeks time to.
You're the award debtor. If you don't want to hurry up, what can
Well, because they're enjoying a stay, the old bank guarantee is there. So, but we are not benefiting from the award, but for the bank guarantee, that's notionally there. So, but we are in really, of course, port trust being as they are, we were out of time with our opposition. But we have served the 19th December. Lordship, I'll give a reasonable time.
No, but AP 755 is Kolkata. That's your.
That's my 34. In
Very
which
well.
opposition has been given by them.
Yes, learned counsel appearing for the petitioner in AP
AP 688.
688. That's not in the list or what?
Yes, the next matter.
In AP 688 of 2023, seeks to file the affidavit in reply. Stop. Let the reply be filed within 2 weeks from date. Stop. The affidavit in opposition you have filed already.
I'm filing.
The
I'm
affidavit in opposition of the respondent Port Trust is taken on record. Stop. And what about your reply?
Well, since Lordship is adjourning for a fortnight, in AP 755, they've given the opposition. I shall give my reply also within that time.
The petitioner in AP 755 of 2023 will also file its reply, capital R, within 2 weeks. Stop. From today. Stop. Next, let both the APs, small s, APs appear on, be listed on. You want 24th or
Yes,
29th?
24th is, but 24th is fine.
There's a holiday before and a holiday after.
I'm here.
Yes.
At the most, I may take the 22nd off. That's all.
Yes. What I'll do is I'll list it on the 29th, and I will give you more time for the replies.
On
29th.
Yes, so well we can start because then the yes, you can.
On list both the matters, list both the APs on 29th
So-
January 2024.
So the replies by
stop.
24th.
Our replies হবে তাহলে affidavit the affidavit reply যে বললাম না within 2 weeks ওটা কেটে দিয়ে লেখো by 24th January 2024.
Get to
My lord, instead of 29th, can it be on 31st?
Yes, you can.
31st affidavit in reply by 25th January 2024.
And my lord, item number 20.
755.
AP number 755, we are also filing our
Yes, the affidavit in opposition in AP 755 is taken on record.
Deeply obliged.
Yes, chamber matters, please.
Chamber matters, monthly list, item number 67, Kotak Mahindra Bank.
Is anybody waiting for the chamber matters apart from you? Anybody else waiting? Which one? Yes, 67. Yes.
My lords, this is my execution application for execution of an award dated 13th of December 2018 for an amount of rupees 33,76,454. My lords, the matter was last heard on 29 September 2021, where affidavit of assets direction was passed by Justice Kapoor. My lords, we had mentioned this matter on 11th of December, and it was supposed to appear as 18th of December, but my lords, it could not be taken up due to paucity of time that day. My lords, I was humbly praying if warrant of arrest could be issued, my lords.
No. First, another opportunity to them, and then. Yes. The last time a coordinate bench heard this matter on 29 September 2021. Stop. The matter was thereafter mentioned on behalf of the award debtor on.
My lords, on 11th of December it was mentioned.
Which year?
11th of December 2023, my lords.
11 December 2023. Stop. Next, there is obviously no urgency in the matter. Stop. List this matter on 1st February 2024.
My lords, we had served upon them.
Very well. 30th January 2024.
They have accepted it, my lords. It was
Yes. The award holder will communicate this order on the award debtors.
Grateful, my lords.
Yes. Any other matter people are waiting for? Which one?
Item number 68.
68, item number 68, Poonawalla FinCorp.
Margaret, in this matter, direction for affidavit of asset had been given, but the service could not be completed. My lord, I'm praying for some time to complete this.
Yes, you're the advocate on record.
Yes, ma'am.
The advocate on record, the petitioner prays for time to complete service. Stop. When do you want to come back?
My lord, after 6 weeks.
List this matter after 6 weeks as prayed for. Yes. Any other matter people are waiting for?
My lord, 69 also similar order maybe.
Yes, 69, Doctor.
Item number 69,
Same
Poonawalla
order.
FinCorp.
Same order.
71. I'm for the award holder, Your Lordship. In this matter, Your Lordship, affidavit of assets order was passed.
You're for 70? No, you're the
I'm for 70. I'm for 71, Your Lordship.
very well. 71, 70 Tadako.
Item number 70, case Atwal.
No one appears for the applicant, petitioner. Stop. List this matter after 4 weeks. Next.
Item number 71, very good.
This is my matter, Your Lordship. In this matter, affidavit of assets order was passed on 8th of February 2023. Thereafter, I had served them, Your Lordship. Then it was received back unserved. So I was playing late, maybe served again by hand.
Yes, the applicant record the petitioner seeks to effect fresh service on the award debtors. Stop. Such prayer is granted. Stop. List this matter after
4 weeks.
4 weeks as paid for. Next.
By hand, Your Lordship.
Service is to be effected by hand as paid for. Next. A leave is granted to effect service by hand. Next.
72, Ascot Realty.
Yes, we order to have it. Yes, a journalist. Who are you appearing for?
Lord, I'm appealing for the petitioner.
You don't know where to stand.
Lord.
Adjournment is prayed for on behalf of the petitioner. List this matter on 16 January 2024. Next.
Item number 73, Gaurav Datta.
Same order. Okay, no one appears. Yes, after 4 weeks. Next.
74, Suresh Kripalani.
Same order. Next.
Item number 75, Mr. Bhaskar Tatto.
My lord, I am appearing for the petitioner
Yes.
in the last order in July.
Hurry up, please.
In 6 July, in this court, my lord.
Don't even know the date, the year. What is this?
6 July 23.
Yes.
My lord has passed the order to pay the judgment debtor to the award holder rupees 27,30,280.50 and instructed the award holder to go and sign the final bill and submit the escalation bill also. That has been complied with. But
you are appearing for who?
That petitioner, my lord.
Yes. So what is it that you want now?
Now I want the attachment of the.
Very well. Yes. You're the counsel. Learned counsel appearing for the award holder submits that the direction contained in the order dated 6 July 2023 has been complied with by the award debtor. Stop. Counsel now seeks attachment of what?
Attachment of the.
Counsel now seeks further orders. Stop. List this matter. When do you want to come back?
Next week, anytime.
List this matter on. You better get ready. Yeah, I don't think you're ready at all. List this matter on 16 January 2024. Stop. The council shall communicate this order on the award debtor.